Hi everybody, welcome to this virtual hearing for the inquiry into floodplain harvesting. Before I commence, I'd like to acknowledge the Gadigal people who are the traditional custodians of the land on which Parliament sits. I'd also like to pay my respect to the elders past, present and emerging of the Eora Nation and extend that respect to any Aboriginal people tuning in today. Today's hearing is this committee's first and is being conducted virtually, of course. This enables the work of the committee to continue during the COVID-19 pandemic without compromising the health and safety of members, witnesses and staff. As we break new ground with the technology, I ask for everyone's patience through any technical difficulties we may encounter today. If participants lose their internet connection and are disconnected from the virtual hearing, they are asked to rejoin the hearing by using the same link as provided by the committee secretariat. Today, we will hear from a number of stakeholders, including scientists, environmental groups, and representative bodies and organisations with interests in water management. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the virtual hearing. I therefore urge witnesses to be careful about comments you make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it's important that witnesses focus on the issues raised by the inquiry in terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days of receipt of the transcript. Today's proceedings are being streamed live and a transcript will be placed on the committee's website once it becomes available. Finally, a few notes on virtual hearing etiquette to minimise disruptions and assist our Hansard reporters. Can I ask committee members to clearly identify who questions are directed to, and could I ask everyone to please state their name when they begin speaking? Could everyone please mute your microphones when you're not speaking? That is particularly important. And please remember to turn your microphones back on when you're getting ready to speak. If you start speaking while muted, please start your question or answer again so it can be recorded in the transcript. Members and witnesses, please avoid speaking over each other so we can all be heard clearly. And I remind members and witnesses to speak directly into the microphone and avoid making comments when your head is turned away. Okay, I now welcome our first witnesses. Could each witness please state your name and position title and swear either an oath or an affirmation? I understand you have those words. I'll start with you, Professor Sheldon.
Thank you, Kate. So hopefully that's a bit clearer now.
That is great.
Excellent. So Professor Fran Sheldon, I'm a member of the Wentworth Group. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but it. So help me God.
Great. Thank you. Dr. Rochetta.
Dr. Eitan Rochetta, Policy Analyst with the Wentworth Group of Concerned Scientists. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Dr. Carmody.
Dr. Emma Carmody, Managing Lawyer of the Freshwater Program at the Environmental Defender's Office. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr. Gambian.
Chris Gambian, Chief Executive, Nature Conservation Council of New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth, nothing but the truth, so help me God.
Thank you very much. Now we'll get to opening statements, which we have requested to be as short and succinct as possible without really repeating what is in your very good submissions that you've made. So I will go first in the order of who we just swore in. So Professor Sheldon or Mr. Rochetta on behalf of the Wentworth Group. Is it you, Professor Sheldon?
Yeah, thank you, Kate.
Great.
So yeah, we welcome the inquiry into floodplain harvesting policy and support the implementation of a licensing framework to rein in the growth of floodplain harvesting diversions. So Dr. Rochetta and I are here representing the Wentworth Group of Concerned Scientists. We're an independent group of scientists, lawyers and business people with a long-standing interest in the conservation of Australia's land, water and biodiversity. In relation to floodplain harvesting, we think there are solutions that can restore the river's ecology to healthy levels, support communities along the rivers, including Indigenous communities for whom the rivers are so significant, and allow for sustainable irrigated agriculture to continue. We see the solution arising from amending the policy to include all of the following measures: improve the modelling process and reduce modelling errors with annual validation and error correction. Introduce flow triggers within each valley, which cover a range of flow regimes and protect higher priority water needs. Remove unlawful structures and ensure all structures on floodplains do not significantly alter natural flows when extraction is restricted. Issue temporary licenses until there is evidence the modelling and policy is effective at delivering expected outcomes for communities and the environment. We thank the committee for their time and welcome questions.
Thank you very much. I'll go to you, Dr. Carmody.
Thank you, Chair. The Environmental Defenders Office would like to thank the Select Committee for inviting us to appear at today's hearing. The EDO is the largest public interest environmental law centre in the Southern Hemisphere. Our freshwater program extends across 8 Australian jurisdictions and notably includes all jurisdictions within the Murray-Darling Basin, where we advise a diverse range of clients, including farmers, Aboriginal organisations, community groups and peak conservation groups, about all aspects of water law and policy. The EDO has long-standing concerns about the administration of water laws in New South Wales and across the MDB more generally. This culminated in our office leading an investigation from 2016 to 17 into allegations of non-compliance in the Northern MDB and collaborating with Four Corners on the seminal episode Pumped. The impacts of our investigation and of that collaboration are now well documented and include multiple inquiries and reports, a Royal Commission, a new water regulator, new metering laws, and multiple successful prosecutions. However, we remain vigilant, including in relation to the implementation of metering laws, the continued funding of the water regulator, and in relation to the regulation of floodplain harvesting in New South Wales. The EDO supports the licensing of floodplain harvesting, but this support is conditional. These conditions include, but are not limited to, the following. First, the volumes licensed must not further degrade our already over-extracted river systems and internationally listed wetlands, and must reflect the impact that climate change is having on water availability. Second, it must comply with the overarching legal obligations contained within the Water Management Act, which in our view requires the implementation of downstream flow targets. Third, it must be undertaken in a manner that acknowledges and seeks to reverse Aboriginal water dispossession. This will necessarily involve an equitable portion of any floodplain harvesting licences being reallocated to Aboriginal nations. Some 30 years post-Mabo, it is entirely unacceptable for Aboriginal people in the New South Wales part of the MDB to own a mere 0.2% of available surface water licences. Thank you.
Thank you, Dr. Carmody, and we'll go to you, Mr. Gambian.
Thank you, Chair, and thank you to the committee for the opportunity to say a few words to you this morning. First, may I acknowledge that I'm coming to you from Biddigal country on the northern banks of the Georges River, and I pay my respects to ancestors and elders. I also pay my respects to the ancestors and elders of the Barkindji Nation and all the First Nations whose country we will be discussing today. In the searing heat of December 2019, I walked where the Darling Barker should have been flowing. I remember the eerie silence. I remember the stillness of that lifeless place. The riverbank high on either side of me, I could have walked for miles and not seen a drop of water. I've walked through rows and rows of rotting citrus orchards, a once viable farm, no longer capable of earning a living for the farmer, nor feeding the rest of us. When the pipeline from the Murray was built to service Broken Hill because the Menindee Lakes could no longer be relied upon for town water, or so the story goes, emus could be found dead along its route. They could smell the water, but they couldn't access it. When I was back in the far west in November 2020, even after the rain had come, you could still smell the stench of dead fish rotting in the water in the canyon. In the town of Menindee, so central to the story Australia tells itself about the outback, water stinks. The water we ask our fellow Australians to shower in brush teeth with, and drink stinks. The conservation movement of New South Wales does not support floodplain harvesting. It is a practice so contrary to the principles of water sharing, so antagonistic to the common good, and so profoundly harmful to the sustainability of ecosystems on which we all depend, that it should be considered not merely illegal, but antisocial and loathsome. The assertion made by some that floodplain harvesting must be licensed before it can be regulated or limited is an obtuse one. Imagine if this were the government's approach in other policy areas. We oppose floodplain harvesting, but we acknowledge that it is a common practice, and we see merit in creating a realistic regulatory framework for it that gives everyone more certainty. NCC has participated in the Floodplain Harvest Review Committee in good faith. However, our representative has been gagged through a deed of confidentiality. The organisation has had far less access to agency staff and less direct consultation on floodplain harvesting than the irrigation industry. We have lodged several dissenting reports on the assessment and review process with Mr. Jim Bentley, the Deputy Secretary. Water policy, perhaps more than most policy areas, is extremely complex. You'll hear that often repeated and will know that from your own experiences. Indeed, too many people stay away from the important debates in water policy because of this complexity in the details of the history, the data and law that have been weaponised to bamboozle and confuse politicians, regulators, stakeholders and the public at large to avoid proper scrutiny. For my own part, I've tried to understand the complexity through a simple framework, which, if you'll indulge me, I will share with you, the 3 M's. First, measurement. This is probably the area where there is the most consensus. We need accurate information about how much water exists in the system, how much is being taken out by whom, and how much is left. I applaud the government for its efforts to get meters installed across the basin. We need even more measurement. It is critical. Second, modelling. Once we know how much water is in the system, how much is being taken and from where it's being taken, we can start to create realistic models for allocations. Critically, climate change must be factored into the models. And finally, management. Creating a management regime that ensures proper priority of use is applied, in this case, end of system flow targets that ensure sufficient water is made available for river health and communities. It'll create a framework that is both sustainable and predictable. Any regulatory framework needs to be realistic. That realism needs to start with 2 acknowledgements. First, that this is an incredibly dry continent that is getting drier because of climate change. And second, that there is not likely to ever be enough water available to do all the things we may want to do with it. We may have ample land, but we do not have ample water. It seems to me that this second reality is the hardest one for many people to swallow. Moreover, whilst I speak today to advocate for the health of the river and its ecosystems, the environment is not a stakeholder. Deal-making and horse trading in water politics over the last 20 years has given rise to the fallacy that the environment somehow exists as some kind of interest group that needs to be balanced against other pursuits. Without a healthy river, communities die, agriculture dies. Its survival is our survival. When it thrives, we thrive. Lake Menindee is full right now. Life is coming back. I'm dreaming of the joy of swimming in the river again. After lockdown, I'm going to get back there. I want my daughters to experience that incredibly special place. Many of you have already been. If you haven't, I hope you go. I hope more people from the East Coast get to visit. It changes you. We must protect it. Thanks so much.
Okay, thank you very much. We'll move straight to questions. We'll go to the opposition for their round. Is that Ms. Jackson?
Yes, thank you, Chair. Thanks, everyone, for coming along today and for your time and for your submissions, both written and verbally this morning. I'd like to direct my question to the representatives of the Wentworth Group, although Mr. Gambier and Ms. Carmody are welcome to comment if they wish. I suppose my question goes to the reference in your submission and your opening statement to the limitations on a capacity to accurately model. There's sort of 2 points there. One, the current limitations on accurate measurement that we have because floodplain harvesting isn't currently measured, and 2, the lack of transparency around the models that have been used. How do these limitations in a way make modelling of floodplain harvesting, sustainable modelling of sustainable floodplain harvesting difficult? And I suppose, how do they tend to your recommendations around annual verification of floodplain harvesting take and some kind of temporary or amendable license regime?
Thank you, Rose, for that question. I will try to answer it. There was quite a lot in there.
We have limited time, so we're trying to cram a lot in. Sorry.
I'll start by just describing the modeling and the model errors and the framework there. So the models are calibrated over a certain period of time, which the models are built to replicate the flow over a fixed period of time. They're then validated over a different period of time. This is a relatively short period for the floodplain harvesting models, around 8 to 14 years. The validation period is the only period where you really prove that the model is simulating the river conditions appropriately and that it is in some way fit for purpose. But in that validation, the reports show that the models have errors, because all models have errors. It is difficult to simulate natural environmental processes. The errors within these models for low flows are a systematic overestimation of 10 to 30%, and there are a range of other errors related to other flow regimes. So this means that when we try to simulate a single year, we know that the model is unlikely to simulate that year correctly. But after the model gets validated and accredited by an accrediting authority, there is no additional public transparency or reporting on annual model errors. So the model is allowed to simulate allowable take, permitted take, without a requirement that the model is simulating actual river flows appropriately to confirm that the allowable take is a reasonable level. We're of the opinion that if that annual validation of the model, so comparing how the model simulates river flows against observed river flows, and a few other validations of outputs from the model, will provide significant transparency and accountability of the modeling to make sure that they are simulating reasonably. If the models are shown to not be simulating accurately for that year, then a form of error correction could be applied to scale down or up the permitted take to make sure that any errors are not adversely affecting the environment and social outcomes downstream, but that it is a fair representation. As you mentioned, there's limited data in terms of measured floodplain harvesting. The models are also limited in that they do not account for return flows. They simulate water flowing out of the river onto the floodplains, but they don't simulate that water flowing back into the river later on. And this has quite significant consequences for the ability to verify environmental and downstream outcomes resulting from various policy settings within the model. We are of the view that the measurement of floodplain harvesting is an absolutely essential, but that it will take time for those measurement numbers to come in to be able to update and improve and verify the models. And that's why we think that a staged approach to licensing is appropriate here, where after specific conditions are met first, temporary licenses could be issued, licenses which have a sunset clause or conditions related to expiration. And then it allows for time for gathering the data, improving the modeling, incorporating return flows, building trust in the system, as well as implementing a number of other recommendations we put forward before the final permanent licenses could be issued.
Great, Rose, you jumping in again, or?
Knees up.
Sorry, we missed that.
Sorry. So it's me. Sorry, I missed my cue. My apologies. Thanks very much. I really wanted to ask the question. Both of the submissions go to the issue of floodplain structures and the dealing of those that exist, or how they could operate under the licensing and measuring and metering conditions. I'm not sure who to throw to. I'm happy for any of you to take that. Perhaps it's one of you, Professor Sheldon, but Happy for anyone to comment on that matter. You know, it's a significant issue.
We might actually also jump with Aiton in as well, but I think you're referring to the issue of removing unlawful floodplain structures. Is that? Yep. So, I mean, I guess it goes back a little bit to what Dr. Acheta was saying around being able to model what happens, and the fact that the model has all the water basically going onto the floodplain and not returning to the river. Part of the problem with some of these structures is that they actually prevent water from returning to the river as well, and change some of that natural flow in other places. And so it's where those structures are having a massive impact on that downstream movement of water that will actually come back into the river. The main issue is. Did you have anything further to add on that?
Yeah, thanks, Professor Sheldon. In our submission, we identified 4 areas where we have concerns in relation to the structures. So one is the issue that lawful structures will continue to intercept, slow, divert, and capture flows even while extractions are not permitted. A number of these structures are set up where passive take occurs, and then that water is actively pumped into a storage, and it's that active pumping which is the real focus of the policy, and we're concerned that that passive capture is still significantly impacts the natural flow regimes. So that's one issue. The second is that there are a range of unlawful structures which continue to be present on floodplain structures. And these unlawful structures have been there for an extensive period of time, and there has been, we are not aware of a program which is actively seeking to remove and remediate these structures. So this is a problem. A third issue we have is that there are structures which will be deemed lawful, but which will have a significant impact on diverting flows which would otherwise have higher priority uses downstream. There are structures which would be impacting flows, and they should be evaluated to determine if those impacts are significant or not, and if they are significant, they should be remediated. And the fourth issue is that there are structures which fall outside of the policy, those which are outside of the designated floodways, and those which are outside of the policy in relation to the extraction of floodwaters. And these will continue to intercept and corral water flowing across floodplains, which ultimately has been identified by the New South Wales Biodiversity Conservation Act as being a key threatening process for ecosystems. So we think that we need to address all 4 components of these elements in relation to structures in order to produce expected social and environmental outcomes.
Can I just follow up on that? I mean, that's a pretty extensive list. I mean, in your view, are there any structures that exist, would continue to exist given those recommendations?
So yes, absolutely. These 4 components are not about removing all structures. They're just about ensuring that the structures are not intercepting flows and diverting flows when it's not permitted. That's one component. So the structures can remain, but they shouldn't be able to significantly capture passively without releasing that water in a very timely manner. The unlawful structures should clearly be removed. And then the risk assessment in relation to structures which pose high risk, there are a potential range of remediation or mitigation strategies in relation to those, but we're not putting forward that those should all be removed. We're just putting forward that they should be investigated in terms of their environmental impacts.
And so the key to that obviously is measuring what's going in and what's going out.
A greater understanding of and public transparency in relation to the location of these structures, the legal status of these structures, how much water they're capable of taking. Absolutely, that's all required, yes.
I'll just hand over to my colleague, Mr. Veach.
Thanks, Penny. My will be to start off with, will be to Mr. Gambian, and then probably to Dr. Carmody. It relates cultural water, and the importance of cultural water, I think, to our First Nations people is undisputed these days. Can you just advise how would you see that working when it's applied to floodplain harvesting? How does cultural water, what sort of regime would be put in place for cultural water with floodplain harvesting?
I might go to Dr. Carmody first for that then. Thanks, Nick.
Thank you for the question, Mr. Veitch. I should acknowledge that I'm coming to you all from the lands of the Gadigal people of the Eora Nation, and pay my respects to elders past, present and emerging. The EDO doesn't speak on behalf of Aboriginal organisations, though we do work closely with and advise Indigenous groups. So I'd just like to preface my response with that statement. If floodplain harvesting is to be licensed, it's our view that an equitable percentage of any subsequent licenses should be apportioned to Aboriginal nations. There was some research that was undertaken by Dr. Lana Hartwig, which showed that in the New South Wales part of the Murray-Darling Basin, Aboriginal people owned a mere 0.2% of available surface water licenses. And this represented a 17% decline in ownership following the separation of land and water. This was off the back of the impacts of several previous waves of water dispossession. So if we are to meaningfully start to reverse this dispossession, it does necessarily mean that a percentage of licences need to be attributed to First Nations in the basin, but specifically in this instance in New South Wales. In terms of cultural water, it's an interesting question. I was having a conversation with a representative from an Aboriginal client group in the Northern Murray-Darling Basin, and she was saying that there's a misconception that it's simply a percentage of water and that culture is just a discrete component of the environment. In the West, we tend to balkanise the environment and should try and divide it up into discrete management zones because that's easier to do. But in fact, you know, when you go out with an Aboriginal group, they'll say, well, the whole floodplain is culturally significant, which means that putting the licensing aside, there needs to be sufficient water to maintain the health of the entire floodplain, noting that that's actually an extension of the river system.
Just,
Mr. Gambian?
yeah, thanks, Mr. Veitch. I concur with everything that Dr. Carmody has said, and will add that NCC doesn't purport to speak for First Nations people either. But time and time again, this question comes up because I suspect that we have this perverse situation right now. To use the Barkindji as an example, they have native title over the land on either side of the river, but not over the water in. And it is, I think, indecent to describe cultural water as merely environmental water. And I think that any kind of regime of licensing, whether it be for floodplain harvesting or anything else, needs to acknowledge cultural significance of the entire healthy ecosystem, but water in particular.
Thank you. I think, Kate, our time must be nearly up.
Yes. I think
Great,
we've
happy to.
30 seconds left, so probably best to move on.
Okay, great. Thank you. I'll jump in with a few questions now, if I can. For probably Dr. Carmody, maybe for this one, your submission talks about how environmental water that's purchased by taxpayers isn't adequately protected from floodplain harvesting under the proposed policy. Is that something to go to you, Dr. Carmody, or is that more Wentworth Group? So just wondering how that can be protected, what recommendations in the proposed policy?
I'm happy to. I'm happy to speak briefly to this. The focus of those comments were in relation to held environmental water being used for overbank watering events. It's our understanding that it is currently not being used for overbank watering events, and as such, there is no proposal under the active management framework to seek to protect this. However, I think that limits potential future behaviours of environmental water holders to undertake overbank events, or to top up and piggyback on a natural flow event to create an overbank event. And as such, we would encourage that the active management provisions are expanded to protect water which is held environmental water that's flowing overbank.
Okay, thank you. I just wanted to get to this issue of BDL, or baseline diversion limit, and SDL, sustainable diversion limit, and just wondering whether we're hearing that like different states as well as New South Wales is looking at, for some of the water resource plans or water sharing plans, increasing the BDL and increasing the SDL. And for Hansard, we'll hear these acronyms a lot over the next 3 days of hearing. Is there like a legal basis for increasing the BDL and the SDL to create new floodplain harvesting entitlements? If that floodplain harvesting, like if the floodplain harvesting was not part of the legal kind of frameworks in 94 or 2009, and I know that's a technical, like, can we just increase the BDLs? Is that maybe you, Dr. Carmody?
Thanks, Chair. There's probably 2 parts to that question. The first is whether or not it's lawful under Commonwealth water laws to increase the baseline diversion limit, the BDLs, and subsequently increase the sustainable diversion limit, which is the method that's being applied by the Murray-Darling Basin Authority. So it's possible to increase the BDL. The question is then, do you need to go through Parliament to amend the basin plan to do so? That's the first question. The second is the inevitable outcome of increasing the BDL that one automatically increases the SDL by the same volume, thereby maintaining the water recovery volume under the basin plan? So in response to the first question, yes, you can amend the BDL. My view is that because there are statutory notes in the basin plan referring to estimates of the BDL, those notes and the estimates should reasonably be amended by the proper parliamentary process. At 6.04 subsection 2, under that there is a note which provides an estimate of the basin-wide BDL. It's somewhere in the order of 10,900 gigalitres. Now, it is an estimate, but it is a statutory note, and under Commonwealth law and superior court jurisprudence, those statutory notes are part of the basin plan. And similarly, the BDL notes in the schedules, they form part of the basin plan. I think it's reasonable for any person looking at that instrument to expect that it contains the most up-to-date BDL, that one does not have to go to a website which has no legislative standing whatsoever to find the most up-to-date estimate. So that would be the first response. I do think if those estimates are going to be changed because they are contained in notes, that should go through a proper parliamentary process to amend the notes. In relation to the SDL and whether it's legal to simply increase it by the same volume as one has increased the BDL, that's a very vexed issue. And I must say that my particular view on that subject is different to the view that's proffered by the Murray-Darling Basin Authority. My view is that an SDL must always reflect an environmentally sustainable level of take as provided for under the Commonwealth Water Act. This would preclude one from simply augmenting the SDL by the same volume. The basin-wide sustainable diversion limit that we have at the moment is not reflective of an environmentally sustainable level of take, which begs the question, if we simply increase it, how can that be reflective of an environmentally sustainable level of take? Now, these are questions for the Commonwealth because it's a matter of Commonwealth jurisdiction, but you're quite right. The proposed augmentation of BDLs and SDLs is part of the question of floodplain harvesting and its regulation.
Dr. Rochetta here. Can I please add a few comments to that? The argument being prosecuted is that the floodplain harvesting was implicitly incorporated into these models, and that the process of reapportioning the losses into floodplain harvesting versus other losses translates through to all of the models so that all the models can be shifted up. But this argument is based on a key assumption that during the calibration period, an appropriate level of floodplain harvesting, which reflected legal limits, was occurring. So that floodplain harvesting was implicitly included into the model. I have yet seen any focus or evaluation of this key assumption, and considering it such an important assumption, I think it should be evaluated before the argument is allowed to be used. And without this, this argument of reapportioning the losses, a re-evaluation of the environmentally sustainable level of take, the ESLT, would be the most appropriate and scientifically defensible approach to updating these models.
Yes, because you have to start there, don't we? We have to start at the ESLT. That's the way, like that's the whole premise of the basin plan. What is that environmentally sustainable level of take? Dr. Rochetta, I don't have much time left. Could you explain why that's so important for the committee? Why it's so important we have to start there and get that right?
The environmentally sustainable level of take is the key underpinning of environmental needs across the basin. In New South Wales, the framework is not focused on providing protections for environmental and social needs. The cap is just a line in the sand, which is an unsustainable level of take. The plan limits, which have been brought in, rein in the cap a little bit, but again, there's no focus on these limits to show that they produce an environmentally sustainable level of take. Whereas on the Commonwealth level, that ESLT is the mechanism to ensure that that take is sustainable. However, unfortunately, the ESLT process was not implemented using best available science. And unfortunately, the ESLT does not represent a sustainable level of take currently.
Excellent, thank you. My time is up. I'll move to the Deputy Chair, Mr. Mark Banasiak.
Thank you, Chair. My first question goes to Mr. Gambian. I note in your submission you are opposed to the 500% carryover in the 5-year accounting period. The modelling entitlements that the DPI have provided suggests that if you go to a 1-year accounting period, you'll actually increase the entitlement or the take by 3.2 times larger. So can you just explain your rationale behind wanting to go to a 1-year accounting period? It seems if it's averaged over 5 years, the average take over those 5 years will actually be less than if we go to a 1-year accounting period.
Thanks, Mr. Banasiak. Look, I'd say probably just a couple of things. One is the problem, to my mind, about a 500% take in a single year. That's the worry, right? Like
Chris, sorry, I'm sorry to jump in. You're very faint. Is it possible?
Oh, really?
Yep.
Is that any better if I do that?
That is better. That is better. Yep.
Sorry about that. I think the concern that we would have is that if there was an ability to take up to 500% in a single year, that would be grossly excessive. We would have an open mind to a system that, at the end of the day, ensures that we have a sustainable amount of take being a management regime that ensured there was enough water left in the system to deliver the environmental outcomes that we need. So don't want to be sort of ideological about it or purist about it, but there needs to be a licensing regime that recognises that sort of these massive takes, and this year's flood events is probably a good example where there has been a lot of water go down the system, but not necessarily enough water to ensure that there's river health right through and floodplain health as well, not just for the environment, but also for downstream farmers and so on. So it's not sort of a locked in stone view, but one that I suppose represents concern about excesses in a single year.
Okay. Thank you. I'll stay with you, but this question is also for Ms. Carmody as well. We have the Macquarie Marshes, which 85% of that is in private ownership of graziers. I'm just wondering what both your organisation's views are of, I guess, unregulated floodwater and environmental flows to those marshes being used for commercial purposes, because it is possible and is happening. So, but it seems to be an omission from both your submissions. I'll start with you, Mr. Gambian.
I think both my colleagues have probably got a lot more to say that's going to be useful on that question than I do. I'm sorry, Mr. Banasiak, so I might throw to the Wentworth Group or EDO.
Yep, sure. Ms. Carmody, did you want to take that, or?
Yes, thank you.
Dr. O'Shannon?
I'm happy to respond to that question. The key issue with the degradation of internationally significant wetlands, including the Macquarie Marshes, is structures on floodplains upstream of the marshes, preventing adequate flows reaching those wetlands. I think that's the key issue here in terms of their health and the maintenance of their ecological character. And there's plenty of scientific evidence to support that statement.
So
Professor Sheldon, I think Professor Sheldon was about to comment as well, I think.
Just quickly, I was going to agree with Dr. Carmody, but also I think part of the issue with the Macquarie Marshes is just the long-term drying. The less frequent the flows actually get into the marshes, the soil moisture and the entire, I guess, role of a wetland starts to decrease, and these wetlands start to become more and more terrestrial, which is a degradation of their wetland function. So the fewer the floods, the fewer the wetting events they get, the more degraded they get, and it becomes a bit of a compounding situation. So.
Okay, thank you. I might just go back to you, Mr. Gambian, just looking at your submission and going through some of your recommendations. I just wanted to ask some clarifying questions. So in recommendation 8, you talked about a revision of the BDL and a reevaluation of the SDL. Noting that included in those diversion limits, there already is a 2750 that's been reclaimed back by the Commonwealth. When you say revision, I'm assuming you mean further reduction. And if that is the case, what percentage are you proposing be distributed to, say, the Commonwealth Environment Water Holder, and what percentage would you see as acceptable being diverted to cultural water or Indigenous ownership?
Again, I think we'd have a very open mind about that, Mr. Banasiak. We don't claim to have the technical expertise of the Wentworth Group or anybody else on these things, but the key principle here is that there needs to be enough water through the system. That's for environment, that's for communities, and oftentimes I think some of those towns don't get enough of a mention through this discussion, and that is for cultural water as well. So I wouldn't want to hazard a guess, and it would be a guess, about what sort of percentages we'd be talking about. But it's sufficient to say, I think, at the moment that there's a system.
Okay, and just I've only got about a minute or so left. Recommendation 11, where you say ensure any changes to floodplain harvesting licence determinations based on growth in use or updated information are not compensable. I just want to clarify, are you, in that recommendation, are you saying that you don't recognise the existing Part 8 renewals that were under the 1912 Act that were being paid by irrigators up till 2 years ago? Or is it any future licence determinations shouldn't be compensable?
Well, I think we're talking about floodplain licences here, and they don't exist.
Well, there's a bit of contention in terms of whether they did exist under the 1912 Act and now they sit in a regulatory warehouse. And given that irrigators were paying essentially Part 8 renewals under that 1912 Act, sort of suggests they did exist in some form.
Well, that's well and truly a view you're entitled to hold. It's not one that we share. And our view is that we shouldn't be creating burdens for future generations of taxpayers when inevitably we need to recover water system.
So it's your submission that any recovery of water should not be compensable.
It's my submission that people should be following the law right now, and we don't think floodplain harvesting is legal.
Thank you. I think that's my time up. Thanks.
Yes, it is. We'll now go to questions from the government. Who's leading on?
Thanks, Kate.
Mr. Farraway.
Thank you, Chair. First question, I suppose, is to Mr. Gambian, just to follow up on your last comment about floodplain licensing, in your view, not being legal. Brett Walker SC has provided independent legal advice on floodplain harvesting to this committee. Have you seen that at all?
I've not, no.
Okay. Well, could I get, obviously, your organisation maybe take on notice what your views are on that independent legal advice that this committee has sought. Just moving on to Dr. Carmody, that probably a similar question around Brett Walker's independent legal advice provided to the committee. Have you seen that at all?
Sorry, just to jump in, Mr. Farraway, you are aware that the committee has only just agreed to publish that. It hasn't been made available. It would have been, highly probably illegal for any members to send that to anybody. So just so everybody is clear, nobody has seen that yet.
Yep, I know what I'm asking. Thanks, Madam Chair. So to Dr. Carmody, if you haven't seen it, are you able on notice to provide the Environmental Defenders Office views on that independent legal advice? Are you able to take that on notice for me?
Yes, certainly.
Excellent. Continuing on with the Environmental Defenders Office, has the Environmental Defenders Office ever received funding or any other support from PIRV's Environmental Fund or directly from Robert Purves?
Thank you for the question. I'm curious as to how it relates to the terms of reference set for this particular inquiry. Perhaps you could clarify.
Well, no, sorry, Doctor. I'm here asking the question. So, again, it obviously relates directly as he's a significant supporter of your organisation. So I put the question back to you.
Well, again, I would request that you clarify how it falls within the terms of reference.
Point of order, sorry, order. A point of order has been taken, Dr. Carmody, by Ms. Sharp.
I mean, my point of order is that the witness has indicated that this is not part of the terms of reference. If Mr. Farraway wants to attack witnesses, this is actually not his opportunity to do so. And I'd ask that he ask questions relevant to the terms of reference, please.
Yes, the point of order is taken. So if Mr. Farraway,
that's right, I'll move on.
Ask questions. Yep. Order. If Mr. Farraway could please ask questions in relation to the terms of reference, and if we could also remember that witnesses should be treated with courtesy and respect at all times. Continue, Mr. Farraway.
Thank you, Madam Chair. So moving on to Professor Sheldon, a question with regard to the Wentworth group of concerned scientists. Any submissions that your organisation make or to government inquiries, are they actually signed off by your board? And does the board have a say on what goes on or what is submitted under the Wentworth group's logo?
We're an independent group of scientists, and so we make submissions as the group, not as the board.
Okay, so the board wouldn't necessarily sign off on whatever final submission that you might put forward, for instance, to this inquiry on floodplain legality of floodplain harvesting.
I'm aware they don't sign off on our submissions. Dr. Richard can double up on that, but we do them as our independent selves.
Okay. The board do not sign off on submissions the Wentworth group makes.
Thank you. Continuing on, Professor Sheldon, are you aware, and I make reference to the Weekly Times article, Wentworth Group of Concerned Scientists Chair Buys Up Duxton Water Shares, August 9th, 2021. Are you aware of any conflict of interest and concerns raised in that article?
Again, as per Dr. Carmody, I don't see how this is relevant to the floodplain harvesting inquiry. There's been a statement placed on the Wentworth website around. It's not relevant to floodplain harvesting.
Sorry, I just need to jump in there again, Professor Sheldon. You're fading in and out quite badly. You'll just need to just repeat your last sentence for the purposes of Hansard and just see if we can hear you better.
Apologies, is that better?
A little bit, yeah.
I was just saying that I don't think that question is relevant to floodplain harvesting inquiry, and there is a statement from the Wentworth Group on our website regarding that issue.
Okay, that was for the purpose of Hansard, and then I'll just note that Ms. Penny Sharp has her hand up for a point of order. Ms. Sharp.
I'm not sure where Mr. Faraway is going with this, but again, I raise the point of order that this is a inquiry into floodplain harvesting. If Mr. Faraway's got questions from the Minister's office that he has clearly been directed to try and smear witnesses here, it's thoroughly inappropriate, and that he should actually return to the terms of reference in relation to this inquiry.
I'll note that, Mr. Franklin, I can see you, Ben. I can see you. Mr. Ben Franklin on a point of order as well, is it?
On the same point of order, thanks, Madam Chair. Madam Chair, my point is simply this, that there's been significant suggestion in a number of the submissions, apart from anything else, about the motivation of various stakeholders and of the government in terms of why this regime is in place in the first place, or the proposed regime. I don't think it's unreasonable and an unreasonable line of questioning to look at the motivation or the potential motivation of witnesses involved in providing their advice as well. In fact, it's entirely consistent with the fact that motivation is addressed in a number of the submissions.
Further to the point of order, Madam Chair, as far as I can see, none of the witnesses before us today are the ones that Mr. Faraway is asking questions about. He's questioning the motivations, at best, of people not before the committee. He should cease and desist and direct his questions within the terms of reference to these witnesses.
Yes, I'll uphold the point of order. So, Mr. Faraway, if you could again return to asking questions in relation to the very extensive, wide terms of reference this committee has and is looking into. And again, please do not make inferences in relation to witnesses when you're asking them questions, which is what you're doing.
Thanks, Madam Chair. A question again to Dr. Rochetto, if that's the case. Has the Wentworth Group ever had access to modelling or requested modelling related to floodplain harvesting?
Thank you for the question, Mr. Faraway. Yes, the Wentworth Group has a deep interest in the transparency related to the modelling and in discussing the detailing of the modelling. And we have had meetings with the department in relation to, or with department representatives in relation to the modelling. Those meetings revealed that our concerns related to the modelling were substantiated, that our concerns were valid. Yeah.
Okay, so yes, you have had access to modelling.
The models are very complex computer systems. We have not been given access to the modeling software. We have not been given access to the modeling output, which is something we have requested. We have not been given access to model simulations of climate change impacts, which is something that we have requested. We have been given access to 2 modelers for a Q&A session.
Okay. Moving on to back to Professor Sheldon, would you agree that if governments brought back more water, that it would increase, it would actually lead to an increase in the value of remaining irrigation water entitlements held by companies, perhaps like Duxton Water?
I'm not a water economist, and so I'm probably not going to comment on what would happen in the market around buying water and changing market share. I'm a river ecologist, not an economist. So any answer I gave you would not be based on any experience.
All right. But Dr. Rochetto, do you have a view on that same question on behalf of the group?
I do not have a view on the economic impacts. I have a view on the environmental impacts, and that is that priority of use legislation, which is New South Wales law, is not being upheld, particularly in relation to these unregulated flow events in the Northern Basin. and this poses a significant risk and concern in relation to environmental outcomes, protecting the environment, and also to the impacts on downstream communities, including Indigenous nations.
Thank you. A question directed to Professor Sheldon. In a lot of what I've been reading, there it clears to be a very significant dispute within the scientific community in and around water and the sanctity of opinions, particularly on how it relates to the basin plan and water resources. I noticed, and I have tabled, I've tabled this also. You've signed a letter with 25 other scientists calling on governments to implement the basin plan. Is that correct?
That was quite a few years ago now, and yes, the scientists did to continue with implementation of the basin plan, not to implement the basin plan. So our call was to stick with it and to let it run its course. The basin plan is a really large adaptive management framework, and so our stance on that, which is outside of the Wentworth Group, which was as an independent scientist, was to stick with it through its first term and then actively engage in the review process, which comes up to 2025 into 2026. So it was don't keep going. We have to see how it actually works out.
Just continuing on with Professor Sheldon, Matt Koloff, Quinton Grafton and John Williams said all the scientists who signed the letter with yourself, and you've just confirmed that, were captured by bureaucrats which had undermined their scientific integrity. So you don't believe you've been captured by the bureaucracy of it all?
Order. I will rule that question out of order. I think we have said repeatedly, Mr. Farraway, to treat witnesses with respect. I can't see how a question in relation to being captured by bureaucrats is anything but extremely disrespectful. Again, in terms of the terms of reference, could you please ask another?
Well, to the point of order, it's referencing directly to the 25 scientists in and around the implementation of the basin plan, which the witness just confirmed. How is it out of order?
I think I have said repeatedly that in terms of the procedural fairness resolution that has been adopted by the House, that witnesses must be treated with courtesy and respect. That question was completely out of line in relation to that, and I am asking you to please ask questions of the witnesses that have come before this parliamentary committee who are treating this very seriously, who have made very good submissions. Please treat them with the respect and courtesy that they deserve.
Okay, thank you, Madam Chair. We'll continue with Professor Sheldon, removing obviously that question as it's been deemed out of order. Referring back to the same reference to that article, John Williams said that the process in that article has led to bureaucrats just buying the science they want. Do you think the work of other academics and scientists who have received funding from the New South Wales government, such as Professor Malin Cooper, that their work, because they received funding, is invalid or somewhat suspect because of, I suppose, the administrative capture?
Again, I personally don't. I mean, I'm not sure that this is relevant to floodplain harvesting, but the research that we do as independent scientists is independent. We receive funding from a broad range of different organisations, government, and different levels of government with different interactions with universities. And I think that we all behave with the utmost,
Yep. Thank you.
I think we would disagree with that paper, and so there's more debate in that area. But I don't think we're captured at all. We provide quite useful information and do it independently.
Following on from that, using the logic in Professor Koloff's paper, is research that is released by companies like Slattery and Johnson, who are paid by private corporations and lobby groups for reports. Do you feel as if
Point of order. Point of order.
Yes,
really,
on the point of order,
the member is flouting your ruling, Madam Chair. This hearing is not an opportunity for him to smear witnesses either coming before us or due to come before us. He has the opportunity to ask questions of the witnesses in relation to their submissions, not to use this as a smear exercise. And I really think that he is becoming way out of order in relation to his approach here, and he should be called to order.
Yes, thank you, Ms. Sharp. I'll remind the member once again to please treat witnesses with respect and courtesy. Keep your questions to within the terms of reference. The terms of reference do not include various lines in relation to the funding or not, or government grants of different organisations. So please keep your questions relevant. Your time's expired. Okay, can I thank all the witnesses for coming today. That is the end of this session. We will break for 10 minutes. Sorry, I'm just trying to find my schedule. We will now break for 10 minutes and we will be back at 10:25. I'll remind members to please mute and turn your videos off for this break. Thank you again for the witnesses for the great work that you do and continue to do for our environment. Thank you. Yeah, we might just admit the witnesses who are here now. Okay, we'll admit the witnesses and we'll test their video and audio. Okay, let's just see who we've got. So just informally welcome our next witnesses. We'll just test your audio and video if we can quickly. So Tim, Tim, how are you?
Yeah, well, thanks, Kate. Good morning.
Great, excellent morning. Brendan Griffiths, no video there, Brendan yet. I might just go to Michael. Hi, Michael. You just unmute just so I can hear that your audio is okay.
G'day, Kate. How are you?
Great, good, thank you. Yeah, Tony, let's go with you. I can see you there.
Hi, Kate. Can you hear me all right?
Excellent, thank you. And where are we? Back to Brendan. We can see you now. Can you hear me, Brendan?
Yes, I can hear you, Kate.
Okay, great. Okay, well, it's 10:25, so let's kick things off by swearing you all in. So if you could each state your name and position title and swear either an oath or an affirmation, the words of which I believe you have in front of you. We'll start with you, Mr. Tim Napier.
Yeah, good morning, Kate. I'll do the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. We'll go to you, Mr. Griffiths.
I swear the evidence by now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Brendan. If you could just say your name and position title as well, please.
Brendan Griffiths, Vice Chair, Board of Rivers, Food and Fibre.
Thank you. Mr. Drum. You're on mute.
Sorry, Michael Drum. How are you? Sorry. Exec Officer, Macquarie River Food and Fibre. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. And finally, Mr. Quigley.
Thanks, Kate. Yeah, Tony Quigley. I'm Chair of Macquarie River Food and Fibre and an irrigator in the Macquarie Valley. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Okay, great. Thank you. I understand there's an opportunity for each of you to make a short statement, or at least per organisation. So can I just see who's going to be making one for Border Rivers, Food and Fibre? Okay.
Oh, look, I'll kick off if you like.
Thanks, Mr. Napier.
Chair. Yeah, look, just very briefly, we're here because we're keen to get this licensing process finished. It's a process which has taken the New South Wales government of all colours more than 20 years after having committed to do so to actually get to this point. So we're keen to see this brought to its conclusion. I think I need to make a comment at the start that our community and our people are heartily sick of the lies, theories, conspiracy theories, and well-heeled campaigns which have been run against us, demonising decent, hard-working people, and this has got to be brought to a stop. And I think there are community leaders or so-called community leaders who are running around creating division rather than unity and progress. So our interest is only in getting this done and moving on, and we encourage the committee to bring this to a swift conclusion and to get on with a process that is long overdue.
Okay, great. Thank you, Mr. Napier. And then we'll go to, is it Mr. Drum or Mr. Quigley for?
Yeah, Tony will make a statement for MRFF.
Oh, okay.
Thanks, Chair. I was only more making it on behalf of myself as much as my members and some of their concerns, because I'm not a floodplain harvester, and many of my constituents in the Macquarie aren't, because we're outside the floodplain. But we are caught up under this legislation and regulations because of the need for the rainfall runoff exemption to be passed so that we're not breaking either one of two laws, that exemption or the conditions that are on our license conditions to hold all of our runoff on farm and not run it onto any public land or other people's farms. So that's really important with us because many of our members are outside the floodplain. The second issue, and I back what Mr. Napier's just said, we would like to disassemble some of the misinformation that's been put out, particularly by southern groups, that we don't believe casts fair aspersions on northern irrigators or floodplain harvesters. And we'd like to look at that in the clear light of day of where storages sit and where allocations sit in those areas that basically shows that the information they put out doesn't hold up to scrutiny. Thank you.
Thank you very much. We'll now move straight to the opposition for questions. Ms. Rose Jackson.
Thank you, Chair, and thank you the people for coming along and the submissions from your organisations and for taking time here today. I'd like to ask a little bit about the impact of the current sort of legal and regulatory uncertainty on the people that you represent. You know, I think one of the things that has come up again is, you know, there's a number of kind of contested elements, whether it's legal contestation, whether it's policy contestation, and whether it's scientific contestation, and how those things play out on the ground for people in your organisations.
I'll kick off there if you like, Madam Chair. Yeah, look, in terms of the uncertainty of the licensing not being concluded, probably the most immediate impact has been an AWD being placed on supplementary water users.
We'll jump in when acronyms come up for the first time during the Macquarie annual water determination. Yes?
Yes, available water determination.
Available.
Which was invoked because floodplain harvesting hasn't been included. They're working on a smaller number, and because we extracted a bit of water in the last 6 months, we've approached the limits of our plan, which incidentally is worked out according to a model, not actually by actuals. It's actually worked out to a model, just to complicate things even more. But what that created in our valley, our supplementary users are many of them are smaller users in the upper reaches of the system. These guys are not floodplain harvesters. These guys rely on supplementary water for their operations. They're only little guys, and because of this process, the regulations having been disallowed, these guys have had a 75% AWD slapped on them, which again, it just shows up the clunkiness and the blunt instrument that some of these water policies are.
Tim, if I might just jump in there, we provided some legal advice to the committee, which dealt with supplementary use being reduced to bring overall take under cap. And what we did provide was the fact that it created inequity in the property rights of users. So in actual fact, you're asking Peter, who's a non-floodplain harvester, to pay for Bob, who is a floodplain harvester's water, which is a problem which needs to be resolved one way or the other.
And Chair, if I could add, add to that. Look, this is the final piece of the jigsaw puzzle that we've been playing for over 20 years in water reform. I mean, it started with the Water Management Act 2000 that moved, that separated water from land. And this has continued on now. We're now in 2021 and we're still arguing about bits and pieces. This is the final part of that jigsaw puzzle. And I think it's about time it was resolved to give everybody certainty, not only irrigators, but the environment, get all the rules set. And I'm sure everyone then will be happy to abide by them. But it's, as an irrigator and a person been involved in the water industry for a long time, this is becoming very frustrating that it's taking so long for all government to allow this to happen.
Thank you for that. I mean, I think one of the things in terms of resolving some of the uncertainty going forward, in addition, obviously, to the introduction of a regulatory regime, a licensing regime, is the metering, the measurement that actually goes along with that, and how important that accurate information is going forward. I mean, are both of your organisations comfortable with and supportive of those propositions around the measurement and the monitoring of floodplain harvesting that is proposed?
Yeah, look, if I can go first. Yeah, look, Rose, we're totally in support of the measurement and management of the resource once it's licensed. It's been part of our frustration that because of the recent disallowances, that has actually been delayed from actually coming into force. So, you know, it's one of the basic tenets of water management that if you can't measure it, you can't better manage it. So, you know, to the extent that applies, you know, in this case, and you know, and those things are still being worked out, and as I say, haven't been put in place yet. Yeah, of course, our people are completely supportive of the measure and manage approach.
And Chair, if I could comment as well from the Macquarie point of view, yes, we're certainly in favour of measurement. The only issue, the only caveat I'd put to that is that the metering that we're already trying to do for regulated water has run into a fair number of technical hurdles for meters of the size required for these pumps. And there needs to be some tolerance here to get us through this period while the market adjusts and gets the size of meters available in the quantities required with the number of people required to install them and validate them, so that we can get to that point. It's not like fitting a water meter to your house in your front garden. It's a very much more difficult process with fairly severe and expensive civil works on pump sites. So yes, we're in favour of it, but it can't be done overnight.
Ask one more question before I hand over to my colleague, Mr. Beach. I think sort of probably you would all accept that, you know, in terms of rainfall runoff capture, you know, not all rainfall runoff capture is equal, and some people are capturing very limited amount of water. You know, it's really it's a pretty basic part, you know, of their landholder right, as we sort of know historically. But there is some rainfall runoff capture that is quite substantial, that is potentially stored in quite large storages. And so would you be open to a rainfall runoff exemption that potentially did not include capture of quite large volumes of water in quite large storages, that in a way differentiated between your bog standard when it rains, obviously some of that water is captured and diverted and goes onto the land, from the more substantial infrastructure and works that may be in place that actually captured quite a large volume of water?
If I may, Madam Chair, look,
Tim, and then Tony, if you wanted to jump in as well.
Yeah. Thanks, Rose, for the question. And look, I think that this is one of the really complex parts of the question, because you know, on the one hand we have you know, a water law which is trying to control how much, you know, or limit the amount of water that can be taken. On the other hand, we have environmental law which makes it illegal for you to allow runoff off your property back into a waterway. And the environmental law, you know, unsurprisingly outweighs or outranks the water law. So there's that part of it, and then there's, well, where do you draw the line between the two? And that's I know in the discussions we've had around the exemption regulation has been exactly around that. You know, at what point do you say, well, you know, this is where this bit stops and this bit starts, because as sure as eggs, it'll happen at 2 o'clock in the morning. When the river breaks its banks and it's still raining and there's 6 inches just been dumped upstream. How do you actually draw the line in that? And I think, as I read it, or as we interpret it, the regulation does the reasonable fist of that. I think the reference there to large structures and large volumes, the structures are neither here nor there. If you're regulated, you've got a volume and that's it. It doesn't matter whether it goes into 20 small ones or one big one. But the overall volumes are the critical bit that will need to be managed over time. And I think the regulation does a reasonable fist of that. Is it perfect? Probably not. Could it be fine-tuned? I'm hoping so, because I think the one thing that's often missed in this point is that this regulation and all these regulations are going to apply statewide. So this is going to apply in places where we suspect it hasn't even been envisaged yet that it would be applied. So yeah, to that extent, I think it does a reasonable fist of it.
Yep. I just want to follow on, Tim, with a question about you've been talking about you've really been talking about the transparency around the data and the data collection mechanisms to sort of ease people's concerns or assure people that people are doing the right thing. Can the sparsity and the distribution of gauges along the river system, can you just talk to us about how that's an impediment and what you would see needs to be put in place to make sure any future regime is able to be metered, monitored and measured?
Yeah, thanks, Mick. Look, in reference to the gauges, just to outline what exists at the moment is that the gauges in the Northern Basin in particular, stream gauges, streams are typically not very well gauged. We have a number of main ones on the main trunk stream, on the Barwon and the Darling, typically at structures, at weirs, or at different points up and down the river. But there are only a relatively small number of them, and there are only a very small number of those tributaries which flow into the main trunk stream which actually have gauges on them at all. Typically the approach up to this time has been that the assumption has been that the gauge in the trunk stream would pick up all those flows below that point, and that was good enough. And up until the last 15, 20 years, that has been good enough. But now we're trying to get a bit more sophisticated in how we're managing the resource, and basin plan and all that sort of stuff has required that to a much greater extent. Then we're seeing that these lack of gauges are a problem, because often it's 1 day's or a couple of days flow between one gauge and the next one downstream or upstream. So it's not easy to get a good, accurate picture of what water is in the stream at any time. In an ideal world, you would have a gauge on every stream, but reality tells us, I guess, that a lot of these streams may only run once every 4 or 5 years. So that's going to be an expensive investment to put gauges on those systems. So it's not always going to be practical, but we've been saying for a long time that the density of gauges on these streams needs to be improved markedly. The other point on these gauges and things is too that, especially at the local scale, some are owned by the local council, some are owned by the Met Bureau, some are owned by the State Department. Not all of them talk the same language, so they don't correspond. The data doesn't all go to the same database. Some of them measure in QMEX, some of them measure in megalitres, some of them only give you a height and don't give you a velocity. Some of them are in places where the stream survey is changed from time to time. So and because they're way out in the back and beyond, they're not easy to service and not easy to keep tabs on. So yes, there is a major issue around the gauging, which could be improved. And as I say, we've been saying for a long time, needs to be improved markedly. Tony, do you want to jump in on that?
Oh, no, I was actually going to go back to Rose's question about the rainfall runoff exemption, just to point out an issue here, or really clarify that the rainfall runoff exemption we're talking about is off developed irrigation land. It isn't the other 20,000 acres of dryland country that might surround an irrigation development. It's the rainfall that runs off in that formed and developed irrigation development that allows tailwater and rainwater capture that was designed to do that. That's the rainfall we're talking about. We're not talking about water that might be flowing in because there's been substantial amount of rain on the farm. We're talking about that specific runoff from fields that we need to contain for all those environmental reasons.
And my last question sort of goes to the modelling and the issue around modelling. Some of the submissions to the inquiry suggest that the modelling, once a model run has been agreed upon and underpins a plan, a water sharing plan, that the modelling should be gazetted as a part of that plan, so that we all, at future date, we all can go back to it and see what the model run looked like. Can I get both the views, both from Tim and probably Tony, as to your views on gazetting such information?
Yeah, look, Mick, I don't disagree with the principle. I just don't know what it would gain. My experience has been, I'm not a modeller, but my experience has been, because the model we have here on the border is shared with Queensland.
Yeah.
So they built the model together for the one resource. So yeah, look, in our most recent iterations of our water plans, we had a previous model and we just always went back to it. I don't think it was gazetted, but it was always there. So both states were going back to the same model because obviously we're dealing with the same resource. Look, I think there are many issues around modelling that I don't understand. I'm not technically qualified to do so. Modelling, I was once told by an expert modeller that all models are wrong, but some models are useful. So to that extent, I think they're largely a black box exercise where a lot of information disappears into it and it spits out an answer which everybody accepts at the other end. So can they be updated during the life of the plan? Maybe, if it's going to benefit anything. But I think the model that we have goes back to 1895 or whatever. It's the 120 odd year one. So in terms of gazetting it, I don't see what it gained, Mick, but I'd be open to discussion on it.
Yep. And Tony, your views before our time runs out?
Yeah, well, Mick, I'm just a farmer. I prefer to operate in the real world, and models frighten me a little bit only because they tend to be a black box to me. But I have no problem with modelling being used for all of these things because it's the only really way you can simulate it. My concern is that if you locked in by gazetting a particular model in there, if you had flaws in it, as Tim alluded to, you lock those flaws in. If someone down the track works out a better way to do it or a more accurate model, which seems to happen all the time, we're suddenly locked into a model that's 10 or 15 years old when both modelling and circumstances have changed. So I understand the principle, but I'm not sure that that's the best solution.
Yep. Thank you.
Thank you. Is there any more questions from the opposition?
Yeah, I've got one quick one.
Okay, Michelle.
Thanks for coming along today. It really goes to this issue around modelling and verification. I mean, one of the big issues has been that there's just such a lack of transparency in relation to verification of the models that exist. Do you have a view about, the models that are there, who should verify them, how that should be done and how often?
Look, I'll have a crack, Penny, for what it's worth. Yeah, look, I think models, as I understand it, can never be perfect. Can they be verified? Yeah, probably to a point. But my understanding is, and Griff, you might offer an opinion here. You've done some modelling, but my understanding is that once the parties agree that it's accurate enough for the uses that they need it for, is when they move on, because there are always going to be issues with models. There are always questions that can and should be asked. But yeah, there's a Goldilocks zone there, I guess, is what I'm trying to drive at. Griff, do you want to add?
Yeah, I agree, Tim, and thank you for the opportunity to comment. In terms of my answer to the question, I think it would be a combination of what Tony said before and Tim, in terms of the fact that the models themselves are imperfect, and we know that. And I think the problem is that, like Tony says, we keep hiding behind the models. I think we've got the ability to start plugging some real numbers into these models, and then they don't become so much modelled anymore. It's actuals, and I think that's what we're all quite interested in, yourselves and ourselves, in understanding what really is being taken, and not these models that everyone seems to hide behind when it suits them.
Great, excellent, thank you. We'll just move to questions from the crossbench. I'll just kick things off. I wanted to go back to the cap, the 1994-95 cap, if you like, on the Murray-Darling Basin cap. Since then, in both of your respective valleys, do you have a sense of how much water storages have increased within your valleys? Has that actually been calculated? And I'll go first to Water Rivers. So, Mr. Napier.
Look, not in any detail, Kate. And look, I guess since our the Water Act 2000 kicked in, it's become the actual size and volumes of storage has actually become a moot point, because the restriction has been not on infrastructure, but it's been by managing the licensed part of the resource. So people are managed by their licenses rather than the size of their infrastructure. So yeah, some people have built storages, but you've got to remember that surface water is not the only water that can be stored in storages, and your own water is not the only water that can be stored in storages, because some people trade water. They'll buy water in from outside over and above what they already have. So in some cases, they need that extra capacity to store that extra stored water. So yeah, look, I think it looks bad, acknowledge that, but it's not necessarily a harbinger of doom that it's triggered a massive increase in take.
Mr. Quigley, is that something you also just care to answer for your valley, if it's as relevant?
Yeah, thank you, Kate. Yeah, there have been new storages built in the Macquarie, and it's probably an ongoing process. And I've built one, for instance, on one of our farms. We built a storage about 5 years ago, way out of the floodplain. It's got nothing to do with floodplain harvesting. It's simply there as a management buffer for us, because remember, a lot of us have to order our irrigation water 10 days ahead of when we expect to use it. So if we cop a storm, rainfall event, whatever, we're still expected to take that water. The reverse is, if we're running late on an order, if a heat wave comes through and the crop needs more water or earlier than we thought, we also need to have water on hand to be able to satisfy those crop demands. So most of the storages in the Macquarie are actually used as buffer storages for irrigation management, and a lot of them aren't big enough, to be of particular use for floodplain harvesting. And I think it's a very long bow that has been drawn by several people that says the increase in storage capacity in the Northern Basin is directly linked to floodplain harvesting take. I've got some pretty good examples of why that is just not true.
Okay, thank you. I'll just go back to you, Mr. Napier, in terms of your response then. So if you're saying it's not really the structures, but it's about the licensing, if you like, of the water. But so what happens, because floodplain harvesting hasn't been licensed and deep high, like it's been acknowledged that it really has been a free-for-all, if you like, for landholders and irrigators up until now. So if it has to be to do with the structures, doesn't it? Because those structures have allowed you to take essentially as much floodplain water during floods largely that you're able to capture.
No, look, again, Kate, it's a bit of a misnomer. It's a bit of a furphy. You've got to understand that floodplain water can only be taken when it's there. So when it's actually flooding. So that's a pretty rare occurrence, and especially in the last 20 years. And as we said in our submission, in the last 20 years, there's been a step change due to climate change, if you like, the reduction in the amount of water that's actually been there. So the incidence of those flooding periods is actually far less now than was the case prior to that. And that's just a fact of what's occurred in the last 20 years. So, and again, regardless of the size of the infrastructure that's there, that assumes that all those storages are filled to overflowing, when the river runs, and that's simply not the case.
But sure, thank you for that response. It is the case though then, and I'll get to the 500% carryover rule in the policy in a minute. But it is the case then that when it does really flood, and you're saying that they're increasingly rare events. They're happening with bigger intervals, longer intervals. But when they do come down, those big structures that you said have been built, and an increasing huge number have been built since 1994, they do capture those really big flood events, because that's essentially what they've been built for. Is that correct?
Look, again, Kate, I don't think that's quite right. I think one of the key concepts to understand here is that you can only take a certain amount through a pump in a day. So if you've got massive infrastructure, those rivers need to run for a long time to be able to fill them. Does that ever happen? Yes, rarely. And maybe they might get close to full then, but I would suspect any of those big structures would only be partially used in normal times, and not used for very long. Typically, those big storages, you need to get the water out of them fairly quickly and into smaller ones to reduce your surface area and resulting evaporation. So I think there's a misconception here that there are big gravity-filled storages where there are big banks and floods come down and the entire flood's diverted off away from the river and sucked up by these big greedy people that shouldn't have it. Typically, these storages they're filled by running water through a pump. Pumps are expensive to run, so they don't run them without good reason.
Do you mind if I just give an example of my own situation that might clarify that point? So I operate a small family-owned irrigation operation just on the Macquarie River, just in northern New South Wales. Our last floodplain harvesting opportunity was in March of this year, which was a significant flood, as you will well know, and so that water has gone all the way through and since contributed to the filling of Menindee Lakes. We had a floodplain harvesting event here that lasted for us approximately 48 hours. My capacity itself to harvest floodplain harvesting water is about probably 260 megalitres in 24 hours. So I was able to harvest about 560 megs or so, sorry, 480 megs or so in that period. And we've had supplementary access for 4 months, so in the river itself. So the river itself has in fact run above trigger levels for 4 months, whereas the floodplain harvesting event effectively lasted for 2 and a bit days.
Thank you. I think in going back to 1994, then the storage in the Northern Basin was 600 gigalitres, I understand. Do you know how much storage there is now in the Northern Basin compared to that figure of 600 gigalitres in 1994, just to get our heads around it?
No, I wouldn't take. No, it's not something that we track, and I know I've seen various figures around, but many of them also include Queensland as well. But you know, so it's easy to get those numbers confused. But yeah, look, in terms of overall numbers, no, I don't.
Can I get a sense then, like clearly there will be potentially some structures that have been built which will have to be, demolished if licensing goes ahead, certain storages and supply works are viewed as legitimate, given licenses, there will need to be though certain structures that will have to go. Has your membership, Mr. Napier, talked about that and what that looks like?
Yeah, look, our understanding of that situation is, Kate, that where if a works is deemed to be inoperable or no longer inactive, I think is the technical term, then that condition is changed on the works approvals, and those works are then deactivated. So that just means that the pump lifting water into the storage is deactivated, either physically or technically. Because if a works is deactivated and is found to be pumping water, then they're breaking the law. So there's no need to actually demolish the actual earthworks. I guess the consideration is that in time, works can be reactivated, whether that be through the trading of water or somebody somewhere else closing down, and that works approval being moved to another location geographically. It would be very expensive to knock over infrastructure like that when legally you can deactivate it by deactivating the works.
Okay, I'm conscious my time has expired. Thank you. We'll go to questions from Mr. Mark Banasiak now.
Thank you, Chair. My first question is to you, Mr. Drum. I know your submission spoke quite heavily on the Macquarie Marshes, and I posed this question to the Environmental Defenders Office just before you about the impact of the graziers. So I note that many of the grazing groups are actually opposed to the regulation of floodplain harvesting. And the Environmental Defenders Office was quite dismissive in saying that, the grazers don't have any real impact, and it's all the structures above the Macquarie Marshes that causes the problems. I just wanted your view of that statement.
Yeah, it's pretty not accurate, to say the least. From our point of view, 85% of the land in the marshes is owned by private graziers, and 15% of the marshes, that's the Ramsar listed marshes, are owned by, or managed by the public. So from our point of view, we're quite concerned in relation to what the water is being used for when it flows to the marshes. Flooding in the Macquarie happens right down the end, which is where the marshes are, and so most of that water, unfortunately, we're concerned is being used for commercial purposes, which is for cattle grazing. We've written to Minister Keane to suggest that needs to be reviewed, because you can't, unfortunately, secure the health of the marshes whilst you've got 20,000 head of cattle running around over 85% of what is supposed to be a Ramsar listed wetland.
Okay. Just picking up
Mark,
on
if I could...
And sorry, just to finish that off,
yeah,
I'm using environmental water for it. That's not ideal.
No, that
Mark,
is a bit of a concern. Mr. Twiddler, you want to add something?
Oh, sorry, I was just going to add though, I really want to paint a picture of what happens in the Macquarie in a flood, because I think there's a misapprehension that all of the flood water in the Macquarie ends up in the Macquarie Marshes, which is not true, because the Macquarie is an upside down river. And let me explain this, Chair. It's a little bit different to a lot of other rivers, although the Gwydir is, I guess, somewhat similar. The maximum channel capacity in the Macquarie happens at Narromine, And the river's capable of taking somewhere around 200,000 megs a day of flow there. So that's a pretty massive river, and that's 20% or so of Burrendong Dam in a day. But by the time you get, for instance, even halfway down then to the marshes and get to Warren, the river channel capacity is only 30,000 megs. So in a major flood, the Macquarie has to lose 170,000 megalitres between Narromine and Warren, which isn't all that far if you have a look at it on a map. So already we've got a massive amount of water that's leaving the river never to return and will never get to the marshes. But even greater than that is the reduction in the channel size from Warren down to Marebone, just above the Macquarie Marsh start. And at that point, the channel capacity at Marebone is 5,000 megalitres a day. So of that potential flood of 200,000 megalitres a day at Narromine, there is only 5,000 megs that can physically fit in the river to get to the marshes. And that's where our water sharing plan, the triggers for supplementary take and all of those other things are all around that physical channel constraint of 5,000 megs a day. So in the Macquarie, at 200,000 in a big flood, and even in a small flood, even 100,000 megalitres in Narromine. So, you know, not a great flood there, but a big enough one. There is only still 5,000 megs that will end up in the marshes. The other 95,000 megs goes out on the floodplain into the effluent creeks and doesn't return. And that makes it quite a unique river in the way it operates. It won't make it through to the Barwon Darling, except for what runs down a couple of the Gunning Bar Creek particularly, might get through, and some of it will break into the Bogan at the very end and make its way over a couple of 100 kilometres to the Barwon, but very small amounts. So most of the water in the Macquarie in a flood ends up on the floodplain away from the river.
Okay, thanks, Mr. Cridley. Just picking up on your comments, Mr. Drum, about the inequity in property rights. And just, I note when I quizzed the Nature Conservation Council about their recommendation that these rights not actually be compensable if there's a reduction. You've got advice from Holding Redlich around floodplain harvesting. What's your view in terms of whether those Part 8 renewals under the 1912 Act were actually constituted a property right?
Well, I think it's quite clear that our advice says, and I think also just made public, Mr. Walker's advice says the same thing, that they are a property right in effect. The issue is that if licensing takes place under the Water Management Act 2000, which hopefully is proposed and will happen, then those rights won't be vested in the individual. They'll be vested back into the government, of which the government will give people access to them via a licence. Now, in relation to the inequity, the one thing I will say is that if you look at some of the other valleys where there's been a cut in supplementary access as a result of breaching CAT because of floodplain harvesting, that just can't simply be sustained. You're asking for Kate Fairman to pay the bill for Mark Banasnia. I mean, that's just quite seriously, ridiculous, to be quite frank, and it can't stay that way. There are two forms of property rights there. One is being promoted or enhanced over the other. It's an inequitable situation.
Okay, Mr. Quigley, you spoke about the metering, and you sort of touched on, I guess, administrative barriers or hurdles that were stopping or hindering irrigators obviously getting these meters in place. And I do know the Irrigation Council just released a paper quite recently about some of those administrative hurdles. Do you think it's fair that NRA lists some of, uses some of these administrative hurdles to, misrepresent non-compliance?
Yeah, thanks, Mark. That's, I guess, a bit of a thorn in our side. It's we struggle with the black and white rulings that NRA make, and we've discussed this with NRA at length, because there are some meters currently in place that can be grandfathered. They don't meet AS 4747 because they haven't been through the Manly Hydraulics Lab. They haven't got a certification. But when they were made, they went through a test bed a test bench certification by the manufacturer, again with their serial number noted, and providing they were within plus or minus 5% on the test bench, I think, and I'm not 100% sure of that, but I'm sure it's a very close figure anyway, and providing they're installed to the manufacturer's original specification, those meters are allowed to be used as an interim measure until they fail and need to be replaced with an AS4747 meter. NRA don't count those meters, even if they've got the LID, local intelligence device, that sends the data off. Even if it's got those attached, they're still seen as non-complying because they don't meet AS4747. But they do meet all of the grandfathering requirements for them to continue as a meter, as a legal meter, until they need replacement. And I guess that frustrates it, that NRA don't seem to be able to find a column for those people that are complying through that allowed method.
Okay. And just on notice, perhaps, you mentioned that you had some examples that you could provide about how a growth in storage doesn't necessarily mean a growth in intake. Would you be able to, on notice, provide some examples? Obviously, de-identified. Obviously, we don't need people's property details, but just some examples where that furphy of growth in storage doesn't equal growth in take can be shown.
Look, it's pretty simple. The floodplain in the Macquarie on the southern side, where I am, ends at the Mitchell Highway. So any storage south of the Mitchell Highway, whether it's pre-94 or post-94, doesn't contain floodplain water because it doesn't get there. Or if it does, the main street of Dubbo's got half a metre of water over it and was all hell to pay. So, you know, the last time that the floodwater got out to us from the Macquarie was 1955, pre-Burrendong. So any of those storages that are to the southwest of the Mitchell Highway and the Great Western Railway line are storages, whether they're built pre or post, are not floodplain harvesting storages of any sort.
Sorry, can I just jump in there? The growth in storage is irrelevant. I mean, the use of the storage relies on a multitude of different circumstances. One is you've got to have a flood event, right? If you don't have a flood event, then you don't use it for floodwater. So the storage can be used for a multitude of different reasons. The Northern Basin has a multitude of storages that have to be privately built, which have been privately built, as opposed to the Southern Basin, which have got all public storages. So, you know, that was a point that was made, that the Northern Basin should invest in storages because they don't have the same infrastructure that's government paid for the South. So, look, at the end of the day, whether there's a storage there and whether people have built bigger storage is irrelevant. What it's used for is the purpose. And if a flood event happens once every 5 years, then every other 4 years it's used for something else. So I think everybody needs to get away from this growth in storage thing because it's irrelevant. It's what is it used for is the purpose.
Okay, thank you.
Thanks,
we'll
Michael.
now
Thanks, Tony.
move to questions from the government. Yeah.
Thank you, Madam Chair. To Mr. Quigley, I've heard it, and I suspect that it's extensively been sort of said within the Macquarie Valley that that floodplain harvesting licensing will be, I think it's referred to as a massive transfer of wealth from downstream of the Barwon Darling to upstream. Is this your understanding?
Thanks, Sam. No, well, I think this is really the same as all of the other water reforms that have taken place since the Water Management Act 2000, where the water licence is decoupled from the land. So it's happened with general security, high security, supplementary water, and now the final part of that is floodplain harvesting. What people need to understand is the value in that water was already captured in the land value. So it isn't just like when our general security water was excised from the land, it didn't increase, it reduced my land value as far as the bank was concerned by the same amount that it increased my licence value. So there was no net gain, and this will be exactly the same position. In fact, for a lot of people, it will be a reduction in value because what they've taken historically is going to be greater than what they'll be allowed to under the licence. So they may be actually losing a third of the value. They'll be going backwards in value rather than increasing it.
So following on, obviously, I've also seen a commentary that's been made that licensing floodplain harvesting will cause the Macquarie to breach its BDL and its SDL? Like, is that your view?
No, no. The Macquarie, fortunately, is in a position where we're using significantly less than our SDL over the last 10 years, and that's confirmed by Water New South Wales in a graph that they made public a year or so ago, 18 months ago, that shows that over the last 10 years, irrigators have used an average of 17% of the total flow in the Macquarie Kajigong system, as compared to the 27% that the SDL allows. Now, most of that is due to over recovery in the Macquarie by the environmental agencies, and particularly the QO, which we're discussing with them right now, because the Macquarie is carrying a lot of the heavy lifting for the Northern Basin. We're significantly over recovered by about 72,000 megalitres of licence. But on top of that, you add our expected number for floodplain, whatever that is, 30, 40,000 megalitres, I don't know. Add that in, we will still, and even if that over recovered water came back from the QO by one means or another, we would still be below our SDL. So the Macquarie irrigators have actually done a fair bit of heavy lifting for the whole of the Northern Basin, and I guess we'd probably like to see that squared up. But no, floodplain harvesting we don't expect anyway, I don't know the numbers, but we don't expect that even to get us near our SDL still.
Okay, so another question I've got now, my colleague Mr. Banaziak touched on obviously the Macquarie Marshes and the ownership and some of the private usage, or it was commentary there, but I suppose for you or Mr. Drum, I just wanted to know, like, your understanding, your organised understanding on the impact of floodplain harvesting on the Macquarie Marshes. Like, did you have any more to add? Obviously we spoke about the ownership earlier, but the actual overall impact on the marshes.
Well, Tony, I'll take that one. I mean, yeah, it's difficult to understand what the impact is, right? So delivery of water via the floodplain down there is supposed to go to the marshes, yet how do you know it's getting to the marshes when it's being used for commercial purposes? Like I said, 85% of the Macquarie Marshes are in private land ownership. It's reasonably well known from the submissions made that those who are at that end of the valley oppose floodplain harvesting because they don't want it regulated and they don't want it measured. And for what reason other than to make sure that that water is going for commercial purposes? And you know, if the upper valley and every other valley in Australia, or New South Wales for that matter, has to be regulated and measured, then so should the environmental usage water that goes down to the Macquarie Marshes, including those that go onto land that is used for commercial purposes, which just so happen to have marshes on.
Okay, I think I changed tack a little bit, and the question sort of open to either organisation, but I've seen in submissions and commentary and media reports that some stakeholders have proposed like interim licences. Like, as industry bodies, organisations, like, what does industry support this at all? Like, or do your organisations support the view of interim licences?
I'll take that one.
No,
Sam, first, if you like. Or Tony, you go. You jumped up there.
No, Tim, you go. I'll follow.
Yeah, look, my understanding, and again, I'm not an expert in this, but any interim licensing it really doesn't achieve anything. What is presumed to want to be changed in the short to medium term is the volumes and the rules around those licenses. In terms to manage the resource, that's how that's done with the rules and the regulations. They can be changed pretty much at any time anyway. So it would matter little whether a license is interim or permanent, in terms of managing that. But it would just add another layer of complexity and delay even further the final licensing of all the resource across these systems. Your turn, Tony.
Thanks, Tim. Thanks, Chair. Look, as I said earlier, this is the final part of the jigsaw puzzle of water reform in New South Wales. It's been going on for over 20 years. successive governments have kicked the can down the road, and we just don't want to see that to continue. We're at the point we got fatigued from doing all this sort of stuff. We want to get back to our day jobs. I think it's important that the licensing be put in place, but it can be controlled by the available water determinations, just like they did with the supplementary in the Guida when the cap got breached. It can be regulated that floodplain harvesting licenses in this water year are only at a 70 or 80% allocation to control that water take if and when a valley gets over its SDL or BDL. So it's not as though this is a set and forget. There are mechanisms of government who can control the volumes of water taken as the climate moves along and all of the other things ahead of us happen, that the government hasn't lost control of being able to do it. They can do it through a process that's already well understood and adjusted to by irrigators.
Mr. Napier, obviously you heard lots about the Macquarie, but with border rivers, what just in general is the impact of floodplain harvesting on the border rivers? Just quickly.
Oh, look, it's very quickly. It's a very valuable part of the overall mix of the water resource. For our people. We have a range of users ranging from people who take very little to some that it's a significant part of the resource, to some who it is their entire resource. So that varies a fair bit across the membership. And obviously in a good year, floodplain harvesting is what puts the cream on the crop across the entire district and across the community. So it is important, and that's one of the reasons why when a drought bites, it bites pretty hard.
So obviously border rivers, Mr. Napier, you would represent irrigators in Queensland, correct?
Correct.
So I suppose my question would be then, with floodplain harvesting having been signed off by the MDBM, the Murray-Darling Basin Authority, and as part of the Water Resource Plan, how does what has been signed off in Queensland compare to New South Wales?
Well, the Queensland process is still underway in a similar parallel sort of process as well, but obviously a different one. Queensland is different in that it has a much higher reliance on run-of-river flows, because Queensland only owns 37% of the upstream storage capacity. And there's a long and boring story around that, and I'll refer you to one of the appendices to my submission around the historical context of floodplain harvesting. But essentially, the two states were going to build storages and manage them together. They built one, that being Glen Lyon. They then failed to build the second, and instead encouraged everybody downstream to build on-farm storages. So that, in a nutshell, is how we came to have a lot of on-farm storages, and in the Queensland case, more so than in New South Wales.
Finally, and I'm happy for either organisation to take this one on notice, but I just wanted to know if either organisation sort of had a view on what possible changes could happen to the management of Menindee Lakes. So, just in general, in and around floodplain harvesting, and obviously down the track once, whether what changes, beneficial changes, could be implemented for better management.
Look, my understanding of Menindee, and I've been there a number of times. My understanding, I mean, Menindee is probably the biggest floodplain harvesting storage in the entire system. That's why it was built, was to capture and store Darling floods to use to release later on for the benefit of the lower Darling and the Murray, the lower Murray in South Australia. So that in that context, yes, Menindee is very important. What can they change? My understanding is there's a few things that they can do there in terms of making management better, that being a structure between Menindee and Coorndilla, so that they can reduce the evaporation losses. I think at the moment, evaporation losses run close to 1 Sydney Harbour a year, between 400,000 and 500,000 megs a year when the lakes are full. So by the time Menindee fills with 2 million megs of a Darling flood, if they hold the water in there for 2 years, then they'll be lucky to get 1 million megs out of it and released downstream. So anything that they can do to improve the efficiency of that storage and the way that it's managed, they have to manage up against the local, the locals having their water resource there, having the amenity of a lake, and all those sorts of things close by. And we totally get that, and this is what makes it hard. Is that there are all these obstacles which get in the way of improving the efficiency of the management of Menindee. I think what we saw in the 2016-17 event was the last time that the lake filled, was that the operators, I think under the authorities' direction, emptied the lakes quite quickly. And that's why the lakes didn't last as long into the next drought as they had in previous droughts. So there are all these competing interests, which makes Menindee very difficult. But in terms of floodplain harvesting, from our point of view, once there are licenses in place and everybody has security over what, that they know that what they're going to get, then a lot of that fear should go away.
Tim, I just want to add to that, right? So Menindee's full, and it was filled, from the last flood event, of which, let's be frank, people took floodplain harvesting water in, March, was it, Tim? You had a flood event up there? It was in March, right? There is still a lack of allocation in the Murray at the minute. Menindee's full. The southern basin aren't, as they would claim, being deducted from the northern basin taking water, as they would say, because Menindee's full, and the northern basin still took floodplain harvesting, and yet there's still some allocation problem in the south. So at this stage, it can't be an issue from the north. It's got to be some sort of issue in the south that needs to be addressed, which there are a lot of submissions that talk to that. I'm just wary of time. There's a couple of points that I'd like to make just to the committee before we go. The Macquarie has made a number of submissions along the way to a number of members of Parliament that relate to the legality of floodplain harvesting. We've been concerned that those submissions haven't been reviewed properly, although the Crown Solicitor's advice did go a long way to confirming that our advice was correct. And I just note that from Brett Walker's advice this morning, that confirms as well our advice from Peter Holt and Holding regularly that floodplain harvesting is legal. And I'd just like to put that on note, that we can have a conversation around how floodplain harvesting is managed into the future, how it's regulated and how it's measured. But I think this morning has put to bed, quite frankly, the question around whether or not it has been in the past and continues to be legal. And so therefore we need to move on and with the regulations or some form of regulatory framework around that form of water taking. Sorry to jump in there.
No, well, I think that's it for me, and I think time's almost gone.
Okay, great. All right. Thank you very much for appearing at today's hearing and for your submissions and for taking part in this process. The committee will now break for a short morning tea break, and we'll be back at 11:40. Thank you.
Thank you.
Thanks, guys.
Thank you all.
Thank you all.
Yeah, you there, John?
Okay, we're just beginning to admit our next witnesses. So I'll just begin with doing a sound check for everybody. We will start with you both, Mr. Watson and Mr. Carl. I think you're in the same room there.
Hello, Madam Chair.
Great, we can hear you very clearly. Thank you. We'll go to you, Ms. Lowen. I think you're there as well. Yes, I can see your video. Just take yourself off mute just to check your sound.
Apologies. Good morning.
Great. Thank you. And finally, Mr. Cole. Oh,
yes. Yep. You can hear me okay?
Yeah, great.
Thank you.
Okay, excellent. So it's now 11:40. I think we can kick off into formalities now that we have everybody. We'll begin with the swearing in. If you could all please state your name, position, title, and swear either an oath or an affirmation, the words of which I understand have been sent to you. So we'll start with you, Mr. Cole.
My name is Ian Cole, Ian Richard Cole. I'm Executive Officer for Barwon Darling Water, and I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. We'll go to you, Ms. Zara Leween.
Hello, my name is Zara Leween. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Mr. Watson.
Hello, my name is Andrew Watson. I'm a Director of Namoi Water. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. Finally, Mr. Carl.
Hey, my name is Daniel Carl. I'm the Director of Namoi Water and a farmer at Weewar. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. And now we'll move to opening statements. Who's giving an opening statement? Very short, if we can, please, for Barwon Darling Water.
I am.
Thanks, Mr. Cole.
Ian Cole. Look, thanks for this opportunity to address you on these issues that have been raised by the Select Committee. You'll see behind me that there's a picture of the mighty Darling River flowing past North Burke, past the North Burke Bridge. And recently we've had flows to this extent. In fact, about 2 million megalitres have flowed past Burke during all of this year so far, which is in stark contrast to the few years before. Most of that water is headed downstream to meet all sorts of needs, including environmental, social, cultural, recreational, stock and domestic and agricultural needs. And these flows have now completely filled Menindee lakes. And during that time, irrigators also have had the opportunity to take some water to fill dams, both through unregulated flows and also through floodplain harvesting. And it is good to see. It demonstrates the nature of this unregulated Barwon Darling River system, a river of droughts and floods and feast and famine. But it also shows that this is the time to take water rather than at low flow. Water taken upstream of us in the tributaries and upstream of us in the Barwon Darling during flood times like this and good flows does not grossly affect flows to Burke and downstream to the lakes and the lower Darling. It's best to fill storages while there's plenty. And our worry is that if you were to kill off floodplain harvesting, more water could be then, or would be then, taken at the lower end of the flow regime, the low to medium flows, that do have a big effect on flows in the Barwon Darling. I will say that the Barwon Darling Water Sharing Plan on the other end of the spectrum, on the drought end, has had some major changes in 2020 when it's been put into place. And those major changes include a resumption of flow rule, the lifting of A-class thresholds, active management provisions in the plan, protection of environmental water and individual daily extraction limits. And they've all, I guess, contributed early on in this year when we had to run the resumption of flow rule to the beginning of this wonderful flow that we're seeing at the moment. So I think we need to look at floodplain harvesting as a good thing in the whole spectrum of the water products that we have available to us at the moment.
Thank you very much, Mr. Cole. And going to Namoy Water, Mr. Watson.
Madam Chair, members of the panel, my name is Andrew Watson and beside me is Daniel Carl. We're both from family farming businesses in the Namoy Valley. Our families have been farming and irrigating here since the 1960s. In the early part of our family's history in this region, our businesses and many others like it were encouraged by multiple governments and their policies to expand irrigation to develop the economic prosperity of the regions. Conversely, the whole 25-year period of my farming career has been focused on irrigation reform, as nearly all forms of consumptive water use have become volumetric metered licences. Successively, we've gone through groundwater reform and cutbacks, surface water, supplementary, followed by unregulated water, and now finally floodplain harvesting. The current process of regulating floodplain harvesting is not a new form of water, but rather the final form of historic legal water take to be regulated, measured and monitored. It may surprise you to hear that as users of water, we welcome this regulatory process. We want to be compliant with all legal limits. We want to ensure that everyone gets their fair share. We want to do our part to protect the environment, of which we are all temporary caretakers. This reform will provide a mechanism for the New South Wales Government to manage the last remaining unregulated form of historical take, and in turn ensure we comply with the limits set by the MDBA plan cap, water sharing plan limits, and sustainable diversion limits. Floodplain harvesting doesn't happen all the time, and it mostly happens in time of extreme wet weather when there's already a lot of water in the system. As such, the impact of floodplain harvesting on the function of the river systems is minimal. The current circumstances provide a marvellous example of this. The Menindee Lakes are full, as are most of the northern basin dams. There is connectivity along all the Darling system, and the southern basin dams are near full or spilling. Yet of the northern valleys, the Guida Valley and the McIntyre alone have had any significant floodplain harvesting in a few months as we recover from the terrible drought conditions of 18 months ago. For any further floodplain harvesting access to be possible, there would have had to have been significantly greater rainfall in the other valleys. In the Namoy, we only get these opportunities every 5 to 10 years. My 9-year-old daughter might remember the minor floods in 2016, but she wouldn't remember the last significant floods in 2012 because she was in her mother's tummy, riding through the floodwaters in a tractor, trying to get out just in case she wanted to come into the world while we were floodbound at home. These events are few and far between, but the importance they have for our businesses, our staff, the businesses that rely on us, and our communities in surviving and recovering from the dry times in between cannot be understated. The proposed regulation will cut our historic legal access to floodplain harvesting by about a third, but this is being supported by our irrigation industry because we understand the importance of this final reform to providing certainty and confidence for all stakeholders in our water resources. Thank you.
Thank you very much, Mr. Watson. And we'll move straight to questions now. Questions from the opposition.
Yes, thank you.
Jackson.
Thank you, Chair. This question is really directed to both organisations, so you should both feel free to comment. I mean, one of the things that has sort of surrounded and infused this debate from my perspective you know, is that uncertainty, legal uncertainty, policy uncertainty, scientific uncertainty, uncertainty about the impacts on, you know, various, you know, points in the river system. And I just wanted to see if you could talk a little bit about the impact of that uncertainty on your members. You know, whilst the regulation of floodplain harvesting remains unresolved, what are the consequences of that for the people that you represent?
Well, if I could begin by answering that, uncertainty is, I suppose, a regular thing in the water game. I go back to when the Murray-Darling cap was imposed upon the Barwon-Darling River back in the 90s, and it took probably 10 to 15 years, or 15 years at least, to get that cap into place, along with some environmental flows. We were involved in that. Then to get a water sharing plan by 2012 took us a long time. We've been working on this reform of the floodplain harvesting virtually all that time. I know during the cap days, we used to talk about the fact that we had to cap the water that was taken from the river by pumps. But we always had set aside in our modelling and our discussions, and this goes back to the 90s, an amount of water for floodplain harvesting. And the government has been very slow to work on it and very slow to get this reform done. But it does, as Andrew says, it completes that last bit of the picture as far as regulating water sources in the Northern Basin. And for certainty, it has to be done. I've got members in Barwon-Darling Water whose businesses would be grossly affected if they weren't able to continue to floodplain harvest, because it forms, a significant fraction of the water that they use. And then I've got communities along the Barwon-Darling, which runs from the Queensland border down to the lakes. Those communities will be grossly affected if the uncertainty leads to the fact that we couldn't do it. But when we look at the legality of it, you're going to receive advice from legal eagles far more skilled in their thinking on legal matters than me. And I know that the industry's got plenty of legal advice as well, and you'll receive that during these hearings, I guess. But it's interesting to me that the government has cooperated with, and governments of all persuasions, has cooperated with the practice of floodplain harvesting for at least over 30 years and a lot longer in some valleys, that it appears to have a legal basis in the Part 2 and Part 8 approvals that we've been given. And government has been working on licensing it under the Water Management Act since the Act was introduced 20 years or 21 years ago. So why are limits for floodplain harvesting enshrined in New South Wales water sharing plans and the Murray-Darling Basin Plan if floodplain harvesting is illegal or so uncertain? It's interesting that a very active and much vaunted water regulatory body, NRA, in New South Wales has not acted against any floodplain harvesters in recent times, as floodplain harvesting has always been available and has been used this time as usual.
If I could speak further to that, Daniel Carl, more specifically to your question of uncertainty, as a younger person, in my early 30s, I farmed with my two younger brothers and our father. We put a lot of effort into employing young people in our community and trying to give them a start. And none of that's possible without us having certainty as to the access to water we're going to have that we can then build a business upon to continue into the future. I've been home for about 10 years now, and my role in our business is business manager, and the amount of time I spend on things like this, instead of being able to be out actively farming and encouraging the next generation of young people into agriculture and into our rural communities, is really hard to do when this uncertainty, which in my opinion is not necessary. This isn't a new process, and as Ian mentioned, it's I think a lot of the uncertainty is unfounded. If we could resolve this and get this in place, the ability for us all then to move forward and get on with improving our businesses, improving our communities, and sort of moving on and removing that uncertainty would be truly valuable to all the stakeholders when it comes to water.
One of the critical elements, it seems, in terms of resolving uncertainty and moving on, as it were the monitoring and the measuring elements of this reform, you know, the introduction of more robust regimes to actually know how much water is being taken and at what time and where's it being stored. And, you know, is that something that, you know, your organisations and the people that you represent are committed to? You know, do you see the centrality of that element of the reform to resolving the uncertainty going forward? And obviously, but both organisations can feel free to comment on that.
Yeah, I think we do, Rose. Certainly do, and I might throw to Andrew on that.
Certainly, thank you. Floodplain harvesting is going to be measured, and it's fully supported by all the irrigation organisations. But if you could see the amount of detail we've been into to measure this, we have to have more measuring devices than we do to pump any other form of water. So we have to have a fully legislated storage meter, which either works through pressure transducers or through radar to measure how deep our dams are. And that has to be telemetrized so that can go straight to the department. We also have to have a gauge board there, which takes an hour and a half for a GPS to see how accurate that gauge board is. My tractor can find itself in the field in a minute and a half and be 2 centimetres accuracy. But we're talking about being down to millimetric access on a gauge board that we take a photo of. So the regulations and the monitoring and the measuring is going to be very, very accurate in this circumstance. We understand that NRA have very, very high abilities to use satellites to track where water's going. We've had some real examples that came out publicly about a year and a half ago of where they were tracking water by satellite. So there's going to be a lot of ability for the water to be measured. So I guess we're supportive of that. We find it's very expensive, and a lot of that cost will be borne by irrigators. But you can have it from us that the irrigators are supporting this.
I think Zara has something to say.
Yeah, thanks, Ian. I think a really good question is we've got to have accountability for this form of take. And one of the things that has been undermining the confidence and the certainty around this form of take is the fact that there isn't publicly available data on how much is taken during a flood. And so we need measurement to match that licensing program so that we can communicate that, account for it, report against CAP and SDL. And to do that, we need a consistent approach to do it, which is obviously proposed already in regulation. And that then cuts out the debate we have about how many 1,000 megalitres or gigalitres is taken. And we've seen, particularly in the last 3 years, a whole range of numbers speculated, but we won't know the number until we start getting actual data back into the model. The moment the model is its best estimate, and it has gone through a significant increase in data input through the healthy floodplains to get it there, but we need actual measurement data in it. And we can't do that. Industry has volunteered that approach, but quite frankly, I think the community expects that of us and wants to see government enforce that on us, and we need that in regulation to do that.
Just one more quick question from me, and then my colleague, Mr. Veach, has some questions too. One of the consequences of that accurate monitoring and measuring that it's great to hear, everyone's so committed to, maybe, not certainly will be, but maybe down the track that some structures, some infrastructure, some storages may be found to be needing to be decommissioned or perhaps even deconstructed. That may be something that is required to occur in order to ensure that the amount of water that is being taken and diverted is within the legal limits. Is that something, again, that your organisations and your members are open to, if indeed it's demonstrated that that is necessary?
If I can start off, and then I'll get the two valleys to explain. So there's a couple of things in that, I might say, Ms. Jackson. It's about if the concern is about illegal works or works that haven't been approved, that's a separate process which forms under the Healthy Floodplains and NRA's role. So that will be addressed through that. And we've seen NRA take people through the local court system where there are unapproved works. The licensing program in its development, however, goes through an eligibility test, and that's really important. So understanding what you've got on farm. Now, what you have on farm might be different from that eligibility test. It doesn't preclude you from using it, provided it's approved. But what it means is that then you're limited by a volumetric license at that level. And so it's the license volume that we need the measurement device to match up against to provide those limits. That structure, for example, storage, that might be deemed ineligible, provided it's approved, it's got other purposes. And I think that's where Daniel or Ian can explain those multi-purposes and why we have those storages. But you need the measurement approach to match up to the volumetric, and then there's all those other compliance mechanisms that can come into play to assess that take over the long term is within those limits. Daniel.
Yeah, thanks, Harriet. Yeah, I think that's a really important thing to note, that the storages that we have on farm aren't generally used solely for floodplain harvesting. They've got a multiple uses for storing, water that we've ordered through the dams, the river systems, through general security licenses that we're storing on farm, through groundwater we might be storing on farm, through all different forms of water. And so that's really important to note that while the storage, as Zara said, they're going to be approved already through water supply works approvals. As long as those structures are legal. If they're not, and as a result, if they're found not to be legal structures and need to be decommissioned for that reason, then that's fine. All of our other structures are licensed, but they shouldn't be being found to be, needed to be decommissioned as a result of FPH licensing, because those storages have multiple uses. And importantly, what that allows us to do on farm is to improve our on-farm efficiency. And there's been a lot of government investment in on-farm storage and on-farm efficiency projects, including building and increasing storage capacity, so that we're able to store and be more efficient with our water use on farm. It's more common for us now to take our water in bulk releases, especially in times of dry lately. In our valley, we've the last couple of summers, we've only had access to our water that's held upstream in the dams upstream of the Namoi through bulk releases. So instead of being able to access the water that we hold in our licenses at any point during that summer, during that crop growing season, we've had to take delivery of it early in the year so that Water New South Wales can be as efficient as possible in delivering it to us. If we don't have somewhere to store that on farm, it means we don't have access to that water. It means we can't grow crops that require watering through the entire summer. Again, the flow on goes on, can't employ people, can't have money being spent in town, all that kind of thing. So those storages, if they're not licensed, by all means, they probably should be decommissioned, but it's important to note the various uses there and the efficiency benefits they provide us.
Yeah, I think if any storages or any other structures found to be illegal, it needs to be decommissioned, no doubt. We have experience in decommissioning assets like this, because in 2006-07, the government chose to implement a cap management strategy on the Barwon Darling, which reduced our annual volumetric limits by 67%. Which meant if you were a very active irrigator with quite a bit of storage like I was at the time, you had to go out and find water to continue to be able to use those assets, or they became stranded. But in fact, a lot of them have been decommissioned over the years because the water is no longer there because of those earlier reforms. And if we look at the buybacks on the Barwon Darling too, I'm reminded of the Tyrrell situation, which the government owns at the moment, has structures on there that have taken years to be decommissioned, but they are slowly being decommissioned.
Mr. Vici, I'll just, in our short time, just a question around the cap. A number of the submissions talk about the 1993-94 cap, and then some of the submissions also talk about the current terminology is cap scenario. This is sort of modelling around the cap scenario for floodplain harvesting. And this may be a question for Zara, but can you just explain what you would see to be the difference between the actual 1993-94 cap and cap scenario that's being used in some of the modelling?
I think they probably will flick to me on this one, Mr. Beach. I'll start off and then they might give you some examples. So there is some misunderstanding around CAP. Okay, so CAP is determined in the Water Act now. Previously, it was a schedule to the Murray-Darling Agreement, and now that sits in the Water Act. That CAP has not changed in terms of its definition, and it refers specifically to the use of hydrological models. And so what happens is you set those models, and what we've seen in this debate is often a reference back to the most recent use of that model, which was for the Basin Plan background documentation in 2012. And it's going back to those models, and it's ignoring the work and the $52 million worth of investment by the Commonwealth to improve the models, which they knew at the time were just an estimate and needed rectification. So there's no difference between the CAP and the CAP scenario. The CAP, in fact, is a scenario which is determined through a required set of inputs into a hydrological model and that outcome. And I draw your attention to the fact that, you know, they sitting here representing the Barwon-Darling today as an advisor to them, their modelling results haven't been updated. So in fact, some of those numbers from 2012 are the current estimates of floodplain harvesting take. But that new information is due to come for both the Namoi and the Barwon-Darling shortly in the next few months, where we've seen those model outputs change in some of those valleys. So like the Guida, it doesn't mean that there's more water. No one's trying to hoodwink anyone. Every state has updated their CAP and their BDL since 2012. Every state. So my question is, do you want New South Wales to lock in information set in 2012 and ignore the Commonwealth investment in the Healthy Floodplains program? Or do you want to take on that new information and make the best decisions you can with it? And so I think that's what we need to focus on. There is some evidence within the Guida Valley irrigated submission that explains some of those changes. But the key here is, do we want to take on this new information? And if not, we want to lock it in with what the MDVA had in 2012. Well, in that case, all other states are changing theirs. Because that's how it's allowed to be established. We will not take on new information. How do we then prepare for climate change and changes in inflow sequences? And I'll draw your attention to other valleys where there was no information at the time to set those limits. We're talking about the Murrumbidgee, for example, that has 385,000 megalitres of rainfall runoff estimated in 2012 and no storage development in their initial CAP scenario because it was considered not significant enough to capture it. And then we have other reports since then talking about storage growth, whether that be in the north or in the south, that needs to be reflected. And so what we've seen here is an investment in the Northern Basin to have that reflected, thanks to the Commonwealth investment, heavily scrutinised, and we need to take that on board and take that on board consistently.
Thank you.
Does that answer the question?
Absolutely.
Thanks, Sarah.
Thank you. Sorry, I was trying to find that little mute button. So just to be clear, just to kind of get back to this this CAP situation. So Ms. Lewin, you're saying that the Murray-Darling Basin CAP is actually a CAP scenario that can change.
So now it sits in Schedule E, I believe, of the Water Act, and that schedule lists out the types of diversion that the CAP refers to, and that the use of a hydrological model using the development at that point in time. So the CAP scenario is the development that exists, that you understand to exist in 93, 94, and then it's run over a climatic sequence, which back when the original water sharing plans were done, only went up to 2000, for example. Since the basin plan came in, those scenarios were updated to go up to 2009 because that's the climatic period for the basin plan. And now with the healthy floodplain period, those development conditions through those rules are run right up until 2019, for example. And I'm potentially the Namoy and the Barwon Darling maybe run up to 20, considering they've got time to do that now. And so that's where you get sometimes changes in these estimates when you reflect that new information of that additional climatic sequence as well. So it might not be just some of the data that you put into it, but definitely with the technology available now and the farm visits that have occurred, understanding what existed back at that scenario is much better understood.
Thank you.
I think the cap is a concept, isn't it? It's what the way it's always been explained at water reform meetings that I've been to is it's not a hard figure, but it's the amount of water that would or could have been taken at the benchmark year of 93, 94, given existing infrastructure and conditions on the river at 93, 94, but then averaged over a long-term climatic sequence. So it's going to be different every year, but the average will remain the same. And if you input fresh data into it and better data, more robust data, the number could change upwards or downwards.
Why do you think there's been so much discrepancy between the, in terms of the estimation of how much floodplain harvesting has occurred in the Northern Basin? I know the CSIRO has modelled 146 gigalitres per year with 429 gigalitres of storage. New South Wales, the MGBA, has estimated 17.7 gigalitres per year. New South Wales government estimated cap take of 103.6 gigalitres per year. Why do you think it's just so kind of unclear and there are so many wild estimates? Mr. Cole?
Well, I couldn't answer that question. It's really not a question that I could answer. I don't know if Zara has any feelings on it.
So I think, and then I'm going to throw to Dan or Andrew this to explain the process that they've gone through for floodplain harvesting. But any modeler will tell you that the better information you get into a model, you improve those estimates over time. And so, yes, there are a range of numbers out there, some very much speculated in terms of numbers that, people think the Northern Basin take, but then there's also differences in models. And so you've got to compare the same conditions and inputs on each of those model runs to get a comparison. This is an issue that, as I explained before, if you change the climatic sequence, you automatically change the period by which that model has been run over. So that number is subject to change. And that's why both the cap and the basin plan are written in such a way that if we improve that baseline estimate information and that data that forms the foundational assumptions on how much water is available and how that's being accessed, that doesn't change the fundamentals of what is happening. It's just a better estimate. And the MDBA explain that very much in their understanding of how baseline can change. But each of those examples, in many cases, make different assumptions. And I'll give one quick example with, for example, when I tracked changes in these types of numbers over time, we talk about estimate at water sharing plan, and then the MDBA came in 2012, made some change in assumptions. And a key policy change that was made in that time was rainfall runoff. And so then that changed where the water appeared in the model. And then now the Healthy Floodplains programs come again and made more changes again in terms of the policy decisions around rainfall runoff. And so you're automatically not comparing apples and apples with those types of comparisons. The other reason is the fundamental improvement in the data set, which is coming in the most recent models. This is why I very much caution the use of numbers in those valleys where the modelling results have been presented by the department those numbers from 2012 or earlier are now superseded by that model upgrade, and that's because of the work that's been done on farms like Andrew's. And so Andrew explained that data input that has happened through NRA and the Healthy Floodplains program to improve the estimate that is due to come for the Namoi.
Can I just check then? Sorry, just to jump in again, just because the time is so limited. Just with these, what we're kind of seeing in terms of revised BDLs, if you like, is what's happened in terms of the environmental, the ESLT, environmentally sustainable level of take. Has there been the same level of assessment and scientific kind of reconsideration, if you like, updated scientific knowledge about the environmentally sustainable level of take at the same time?
So the environmentally sustainable level of take is your baseline conditions minus a reduction in water that is now being, in most cases, being handed to the environment as a licence through various programs. And so that re-estimation of the number in most cases changed.
Can I just jump in? So just to really check with the ESLT, that's the first thing that has to happen, right? That's the fundamental first thing that has to happen is what is the requirements for the environment? Just to clarify, I'm pretty sure that's the law. What are the requirements? So the question is, has there been updated scientific knowledge applied to the ESLT at the same time as the BDL has had all of these kind of reassessment within, say, GWIDA?
So what I will say is that when you make the assessment, and I don't think the ESLT needs to be updated because that work was done, we are taking things that were considered losses in the model and now attributing them to take. They, in most cases, weren't contributing to the shortfalls in ESLT because they're happening in a flood. And so we're talking about floodplain harvesting when there is sometimes a metre worth of water flowing across a floodplain. And that's a very different situation to the ESLT. Most of the work that was done in those assessments under the basin plan were focusing on the areas where the MDBA or the tube could influence an environmental outcome. And that's when water's still in rivers, because once it's out of a river, there's no management that can happen. But what you can do is if you reduce the amount of water that is taken in a flood, and that is proposed for largely most of the valleys, GWIDA and McIntyre so far, you then may put floodwater. So in a system of ours, it's putting some water back into those wetlands and areas that are already inundated, as we've seen this year. And so I don't agree that the ESLT needs to be redone, particularly if we are keeping our extraction limits back to those legal limits that are defined. And you've still got that water that has been calculated to be needed for the environment, because we're recognising we're in a flood scenario. But Andrew, did you want to explain some of the work that has been done to estimate how your farm works in the model as well?
Well, agreed. So there's been new technology come in. So previously you've got a dam, you can look at it from a satellite, is it full or it's empty? And it's a bit hard to tell how much water is in a dam from space. So some new technology of LiDAR data, which can actually measure how far up the dam wall it is and be able to calculate that. But they've also have to come and do a survey of each dam. So that's a literal GPS survey of someone driving through each dam to actually chart how big that dam is. So there's been a lot of that sort of stuff happening, and none of that's cheap. And if there's any water in the dam, it makes it a bit harder for people to wade through. So I was also going to reiterate one of the things that Sarah mentioned, which is rainfall runoff and/or other water we have in those dams. If we have rainfall runoff if it rains on our farm just after we've irrigated, a lot of the time we get more water on than we put off. That suddenly turns up in our tailwater systems and we put into our dams, because legally we aren't meant to let that water get into the waterways because of increased nutrient load or chemical load. So we're really finding that once we get down to things like rainfall runoff, we're sort of stuck between two rocks, but it will influence how much is thought to be held in these dams if when they start thinking how much floodplain harvesting will be?
Thank you very much. My time has expired. Now to questions from Mr. Mark Banasiak.
Thank you, Chair. Part of this inquiry, we received a briefing from the department, and part of that, they answered some questions around metering, which is obviously a feature in many people's submissions. And they painted a picture that everything was going along swimmingly, but then NRA did a media release and a report that stated there was significant non-compliance. And I do note that the Irrigators Council then released a fairly detailed analysis of what they call compliance barriers, which sort of raised some significant concerns about the department maybe being a bit misleading in their self-appraisal. So I just wanted, I guess, the lived experience from you guys and your members in terms of how that metering regime has been going along. I'll start with you, Ms. Lewin, perhaps, or...
I think Daniel.
Daniel's taken his mask off, so I'm going to let him go because he's
go for it.
living some of the challenges that have been experienced that we've been communicating.
Yeah, I'm happy to take that on. And so just to be clear too with metering, and thanks for the question, that applies to not just with our storages and with FPH, but to all our forms of take and our groundwater works and our surface water works as well. But in terms of how that process has worked, it's been quite challenging at times to get a good understanding of what meters actually meet the new requirements, and then in getting access to those meters, they're not, there's not shelves full of them. I won't compare them to toilet paper in COVID lockdown situations, but it's not always that easy to get hold of meters, and then to find a duly qualified person to install them has been a challenge. But as an industry, it's better metering is something we've been asking for much longer than these new metering processes have been in place. We've been asking the department to improve the way our take is metered. One, because it's the best way of proving what we already know to be true, is that for the most part we're trying to do the right thing. That there's, as with any group, that there might be people that look to go outside of the rules, but for most of us, what we're trying to achieve is to use the water we've got a legal access to as efficiently as possible to get some good outcomes for our businesses and our communities. And if we've got a good metering framework in place, it's really easy for us to be confident in it, but even more importantly for the rest of the public to be confident that we're only taking the water where we're able to access legally, and then that we're using it appropriately. In terms of storage meters and things, that's going to be another process of accessing those meters and understanding the program in place. In terms of non-compliance in that NRA report, I think what that failed to really properly describe is those instances of what, if you want to look at it in a black and white scenario, where people might have been non-compliant in the sense they didn't have an approved meter in place yet, then sure, they're not compliant. But there's a lot of a fair chunk of that percentage were people who had gone to an effort, had a meter ordered, had measures in place that they were actively seeking to get that meter in place, but it had barriers, as the term was used by Irrigators Council, to getting that in place. And I think not long after that, NRA did come out with some, probably more transparent figures that said actually it's been a lot better than what we possibly sort of portrayed in the first instance. It's certainly through no lack of intent or willingness from our side of things to get this in place. One last example from me is that we actually try to get in front of this in our business and install some meters at our expense, and they're not cheap. They cost, depending on the model, anywhere from $10,000 to $15,000 per meter. We had 4 of them installed prior to the requirements and the approved meters coming out, because we wanted to start that process while we had the cash flow to do so. And those are now not approved. And so they're one of the ones where if NRA were to describe it in black and white terms, they'd say that that's non-compliant. But in actual fact, it is because it's being grandfathered through, and we'll have the ability to replace that in time. But it has the ability to be has telemetry, has the data logger, has all that sort of thing, and we can utilise it still to the standard required until we get an opportunity to replace it.
How, given that this is sort of tranche one, sorry, who was that?
I think that was Andrew, wasn't it?
Andrew, you wanted something to add?
Well, I can see where your next question's headed, but I can work towards that too. But I'll admit that we've focused on putting 28 metres on various bore and river pumps. We spent over $30,000 putting new approved meters on river pumps, which then both failed. So the speed which companies have had to develop these meters has meant there's a lot of weaknesses in the system. And so we've had to go through a process of refitting more meters to replace the ones that we first fitted. Now, the demand for that in that first tranche, which is a limited number of the plus 500 mil pump sizes, does make me concerned that there will be a very distinct lack of meters coming into the next tranche of more meters to be fitted. In addition, I don't know where the duly qualified people are going to come from. You might be able to claim that there's 156 of them around the place, but most of those companies do other things as well, and it's only a portion of their time. So one of my big concerns, and the things that our organisation is advising all of our members, is to get in there as quickly as possible and get everything ordered and make it happen before the due dates. But there would be some real concerns that those issues are going to keep coming up, those compliance issues, because of lack of supply of either the people or the meters.
You anticipated my question perfectly. Did you have anything to add, Mr. Cole or Ms. Lewin?
Well, I think there's probably truth in both the arguments, or a degree of truth in both the arguments. There are some people who are non-compliant, but the number of compliance is much bigger than was at first talked about in the first NRA report, and that was corrected to say how many people were actually on the road to compliance. And from the Irrigators Council point of view, there have been barriers, and Andrew's touched on a few there. And obviously COVID has been a big barrier as well in the supply of the telemetry items and metering equipment that are needed. All the same, that's no excuse. I think, as an industry, we need to get on and get this job completed, and I'm sure you'll see that done very smartly.
Thank you.
Go. I think we've done.
Yeah, so I was just going last question in my limited time. It has been raised by other stakeholders about a concept of an interim license or a temporary license, and we had that sort of pushed back against by our previous witnesses. But I just wanted to hear your view on that said proposal of an interim license or a temporary license. Is such a proposal even feasible?
I'm happy to answer that, Daniel Carl. We spoke about uncertainty earlier in this session. A temporary license does nothing to improve, take that uncertainty away and improve the confidence that all stakeholders can have. We've got water sharing plans that are reviewed every 10 years. There's opportunity to review these licenses going forward, as there are with all other forms of licenses. To put a temporary one in place would simply be kicking this can further down the road, and it's been rolling down this road for nearly 20 years already. So I don't see that as an outcome that would benefit anyone, and it's certainly not one that we support.
Thanks, Mr. Carl. We'll now go to questions from the government. Mr. Farraway.
Thank you, Madam Chair. Question to Zara from the Barwon-Darling Water. In your opinion, do you believe that floodplain harvesting is occurring in the Southern Basin?
I think given the way the Water Management Act is written and the definition of overland flow, we have floodplains right around New South Wales and into the Southern Basin in both Victoria and South Australia. I cannot foreseeably see how it isn't if we don't get a resolution to rainfall runoff. So obviously that definition of overland flow includes rainfall that is collected. It doesn't define it whether it's within an irrigation area or outside that. And so that, in my understanding, brings everybody into the floodplain harvesting definition. I think there's a lot of people that wouldn't recognise themselves as floodplain harvesters, and I understand that, but unfortunately the definition is written that way, and it's been suggested as part of the regulations to make amendments to that to provide some clarity for those people to collect that rainfall runoff in their tailwater. But we have floodplains all around New South Wales, and water flows across farms, and we've got flood protection works all around New South Wales. So I'd be very surprised if it doesn't happen elsewhere.
So just continuing on with that theme, are you aware of some of the growth of the on-farm storages which have been built in the Southern Basin, since 93, 94?
I'm not across numbers of that, and I think I referred earlier to that discussion around cap and locking in conditions under a certain estimated assumptions back at a certain time, and in referring to the Murrumbidgee. So the original cap model that was done to provide their water sharing plan decided not to put in on-farm storage as an element of that model. It was shown to be not a significant influencer in terms of how they took water, but I think we've all seen, and we've seen reports on the ABC and others by some pretty prominent people who talk about storages, particularly in the north now, but in the past raised concerns about increases in storages in valleys like the Murrumbidgee, and currently that's not reflected in their model. But I think that's up to New South Wales to do some work there.
Just continuing along that theme, are you aware of an article that was in the Weekly Times on the 21st of October 2020 titled "Southern Murray-Darling Basin Irrigators Are Floodplain Harvesting"?
Yes.
So from that, and I have sent that to the Secretariat to send out to have tabled, but that article does show a lot of satellite imagery which shows the dams which can be filled by a large channel near Mirrell Creek, I think it is, on the around the Mirrell Creek. So I suppose that the question is, in your view, are these flood works from that article, are these flood works the same or similar as the works on properties in the valleys in the north which do need a floodplain harvesting licence?
I'm not across the particulars of that farm exactly. So there's a couple of aspects that I'll raise here. With the eligibility criteria in the Healthy Floodplains program, it's very key that we talk about the infrastructure that was developed prior to 2008 as that cutoff. But I will say part of the process, I don't know whether Mirrell Creek is regulated or unregulated as determined in that valley. I'll leave that there. But if water has broken out of a creek and is being intercepted by infrastructure, that's in general terms how in the north it happens. So we have floodways which allow the water and flood water which is broken out of a river to flow across the floodplain. And in some cases, the most common example of floodplain interception is where there's a below ground channel that transfers regulated or other sources of water between those floodways. So that flood water is coming through a floodway, and a channel is below ground there that may intercept some of that flood water flowing across and then moves into a storage. That is the most common example of how we floodplain here in the north, and if that's how that infrastructure works, potentially that's an example of how it happens in the south.
So based on that, it would be fair to say then that similar infrastructure, or it would be fair to say that farms that have similar infrastructure in the, as we've just discussed, that if they had similar infrastructure, they would be required to get a floodplain harvesting licence, wouldn't they? If referring to that article in terms of the infrastructure that's
Point of order, Mr. Chair.
Yes, Ms. Sharp.
Sorry, I mean, I just think that Mr. Faraway is asking Ms. Lowen to answer a bunch of hypotheticals without I mean, she can answer them if she wants to, but I just believe that this is a bunch of hypothetical questions that actually don't go to the terms of reference of what we're looking at in terms of this inquiry.
I just
to the point of order, Madam Chair.
Yes, to the point of order, Mr. Franklin.
A question can't be ruled out because it's hypothetical. This is clearly utterly in line with the issues that we've been discussing all morning, and it's totally appropriate for the witness to answer how she feels fair.
Thank you. I'll allow.
Yep. Okay. Sorry.
I'll allow Mr. Farraway to continue asking the question, but just remember to be generally relevant to the terms of reference, please.
Thank you, Madam Chair. So the question was, because you, Zara, had reference to that article, you knew what I was referring to. I was referring to the infrastructure that is quoted and the imagery that is in that article versus how you just described how floodplain harvesting works in the north. It's the same infrastructure, correct? So it has to be licensed in the north, whereas there's question in the south.
As I said, I'm not across the very specifics, but yes. This is a floodplain harvesting policy for the state of New South Wales, but it's a decision for government where they implement that. And our groups here would all say that we think consistency is important. However, we're not in control of where that policy is implemented. That's a decision for government. And at this stage, it is the 5 northern valleys of which we recognise and accept that we take a portion of floodwater when it crosses across our farms. We do that in the way I described more generally, but again, I think it's a government decision and government needs to make a decision of where they want to implement that policy.
Yeah, I think it's covered from the rainfall runoff regulation. But just so moving on to Mr. Watson and Mr. Kale from Namoy, would you be able to explain what block releases are? Obviously from the headwater dams in the Namoy and the Guida rivers.
Yeah, happy to. So I actually looked it up, and if I could share it with you, I would. But in the since we had a wet period in the winter of 2016, we had water released in under normal sort of scenarios from Keep It in this valley under general security licenses, and we were able to access our water that way. As such, the river here basically had water in it up until around the sort of January of 2018. And that was released in block releases. So what a block release is effectively is that when the river doesn't have natural flow in it, for delivered water to be, I guess, sent down river on the back of, in order to be as efficient as possible, Water New South Wales will coordinate with water users when the best time will be for them to receive their water, and then deliver it in a smaller period of time to make sure that as much of that water is being delivered to the user, and we're not losing a bunch of it to transmission losses and things like that. So if you consider that, I guess it's a bit like if you had you know, a limited amount of water to water your garden with, and would you put it in a deliver it straight from your hose into your watering can, and then you can use the watering can to put it on your garden beds, or whether you're just stuck with the hose that a dribble and you've got to try and spread it out that way. That meant, in terms of us being able to efficiently use our water, we could get it there on farm and then use it through the course of the summer to grow crops, rather than us being really limited in how much water we could access through the river, and a whole bunch of water effectively being used inefficiently to deliver small volumes of water.
So obviously, have the increased drought, and I'll just continue along that theme, have the increased droughts over the past 20 years led to more times that block releases are needed, which obviously in turn would increase, which would then probably lead to an increase of on-farm storage?
Yeah, in my time at home, so I've returned full-time to our business in 2014. In that time, there's probably only been two seasons, so water years, which is basically a financial year, where we've had regular delivery of water. By which I mean I can jump on IWAS, which is the Water New South Wales water accounting system, and order water and have it be delivered. Every other year since I've been home has been under a block release program. which, like I say, means we need to be able to store that water on farm so that we can continue as high a level of production as possible through those summers where otherwise the river wouldn't have been functioning. And environmentally too, there's a benefit there, because without those block releases, without our access to FPH in 2016, we were able to fill up on farm and save water in our accounts and keep it upstream. And then that water then being delivered in block releases over the following 2 summers when otherwise the river wasn't running. There would have been zero flow in the Namoi for a 3-year period instead of the 12-month period that did eventuate in 2019. So I think that's really important to consider too, that what FPH allows us to do is access water in times when there's a lot of it in the system. We can store it on farm, and that then delays our need to draw down on our dams upstream, which one improves our productivity over a longer time and our ability to support our communities, but from an environmental aspect, it means there's water being moved down the river for a much longer time period after it stopped raining. And that's an important thing to consider too, that every drop of water that comes down the river serves more than just one purpose. And every bit of irrigation water or water being delivered to consumptive use, as long as it's in the river, is still providing an environmental benefit.
Did Zara or Ian have any comment on that as well? I think you wanted to say something, Zara.
I just wanted to explain that this is another one of the misconceptions, is that storage growth, so X% of storage growth equals a corresponding percent in floodplain harvesting growth. And as Daniel's explained, there's a whole range of reasons why there are storages in the Northern Basin. Mr. Cole explained to you, with unregulated entitlements, they can only take that water when those pumping conditions are available, similar to our supplementary in some of the upper catchments. So that those purposes and those reasons can also explain in the fact that we've gone to a management system in terms of sharing flows since the water sharing plans came into place, that's required the use of those storages for those other purposes as well, including the key one being the environmental provisions in making sure tailwater is not left released off farm.
Mr. Farraway, I'm on the Barwon Darling, which is an unregulated river. We don't have a dam, but if you would like to send us any block releases, we'd accept them quite gratefully. We don't get them, but we do prefer to take our water at times like this. You can see behind me, when the water's right up underneath the North Burke Bridge, that's the time to take it, because you get all the benefit downstream. And, no one can tell any difference downstream how much water has been taken out because there's so much there to start with. Now, the Darling floodplain at Burke is about, in places, 40+ kilometres wide, and we can have 500,000 megalitres flow past Burke at night while we sleep. So that's the time to take water, when there's plenty, not in the low flow range. And I'm quite concerned about this this floodplain harvesting direction that we've taken, because this is one of the most sustainable takes that we actually use in the irrigation industry.
Okay, I wanted to ask this question to all both the Barwon Darling Water and Namoi Water reps, and that is, obviously there's a fair bit of emotion around with floodplain harvesting. And I'm not sure if you've had a chance, but this morning, Brett Walker SC, who essentially was commissioned on behalf of the committee and Parliament to provide independent legal advice about the legality of floodplain harvesting, his advice was released this morning. I'm not sure if you've had a chance to, anyone had a chance to read that yet or review that. And if so, either take the question on notice, but if you've had a chance to do that, I suppose my question is, what is your view on that, and do you concur with that view?
Zara, I haven't had a chance to read it. I saw a report on it that Brett Walker had come out and said that floodplain harvesting was legal. That's all I know. I haven't read any detail. Have you read any detail?
I read over the advice very quickly, Mr. Farraway, but look, I think I'm not a lawyer in this. I've got a hydrology and a soil science background and about 15 years in natural resource management and water policy. But for me, when I went through it, it added together the Crown Solicitor's advice and some of the other advice we've seen from some of the other experts. And I think it's really important to focus on expert advice when it's available in this sense. It's, you know, we're just experiencing a pandemic and how important it is for people to go to the trusted source of information, and that's really clear. And in this case, we've got a senior counsel providing advice to your committee that refers to all the other advice that's been provided. And, you know, I think that's, to me, you know, just because it might suit my understanding of the situation, I think it's important to accept that form of advice when it's provided.
Did Andrew or Daniel have any view on that?
Pretty much the backs are up in that one. You know, we're not lawyers, but when Brett Walker's advice seems to mirror what our own advice we've gained and what New South Wales Irrigators Council has got, it all seems to point in the same direction, that we don't think it's illegal to take floodplain harvesting, and it's just another form of take that will have to be metered, monitored and measured in the forthcoming years, and very soon, please. Thank you.
And can I say, we've been here before. You know, we saw in the ICAC report that organisation was very critical of things that needed to be done in the Barwon-Darling water sharing plan that weren't implemented by government. And so we've said here a number of times, this is a historical form of take. It needs that recognition in terms of a licence so that you can better manage it and better account for it. But 20 odd years now, we could talk about models and uncertainty and things for another 20 if you like, or we could make a decision and move forward. And I think that's the crux of where we've got right now. We've seen a version of regulations. You've made a decision on those regulations. We're having this inquiry and we're getting additional sources of expert advice come in. But I think what everyone's calling for is time for change, and to recognise it and ensure there's accountability of it. And for that, we need regulations that enforce that, so we can follow those steps consistently.
Thank you. Okay, with that, we have now run out of time for this session. So I'd just like to thank you all for appearing today. The committee will now break for lunch. The live hearing will continue, if you like, just with a screen on. So please turn your video off and mute, and we'll be back at 1:25. Thank you.
Thank you, everyone.
Thank you.
Thank you all.
Okay, let's I think we can just quickly test everybody's audio and video just before we kick things off formally. So hi everybody, we'll go to you, Marianne. I can see you okay, and
Can you hear me?
Yeah, great. Yep, that's excellent. We'll go to Matthew, you're next on my screen. Can you hear me okay if you unmute? Yep. You're right, Matthew, can you hear me? No, I don't think Matthew Coloff can hear me. No? We'll go to, where will we next? Bill Johnson?
Yes, I can hear you.
Okay, great. So the Secretariat just needs to, I think Mr. Coloff's having trouble with his
Yeah, no, it's all right. Can you hear me now?
right now.
Yeah.
Okay, great.
I'm okay.
All right, we've worked that out. Excellent. Okay, let's begin. So welcome everybody. We'll now formally start our next session. We'll begin by swearing in the witnesses. So if you could each state your name and position title and swear either an oath or an affirmation, the words of which I believe the Secretariat has emailed you. So we will start with you, Ms. Marianne Slattery.
I'm Marianne Slattery. I'm the Director of Slattery and Johnson. I swear an affirmation that I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. We'll move to you, Mr. William Johnson.
My name is William Johnson. I'm a director of Slattery and Johnson. I'd like to make an affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And just as we move to Mr. Coloff, can I just remind everybody to please mute when you're not speaking? I think we're starting to get a bit of feedback. Dr. Matthew Coloff.
Yeah, I'm Matthew Coloff, Honorary Senior Lecturer at Fenner School of Environment and Society at the Australian National University, and I affirm that I solemnly, sincerely declare that the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
Thank you very much. Now, for short opening statements, who would like to make a short opening statement? Ms. Slattery or Mr. Johnson, do either of you have one?
Yes, I'll make a statement. Thank you.
Thank you.
We just observe that there are no reliable figures for take from floodplains in northern New South Wales. New South Wales Department hasn't demonstrated that it can license the proposed volumes and keep extractions below cap. We're concerned about the processes used to license floodplain harvesting. As a couple of examples are using a cap scenario model rather than the formal cap model, and linking the sustainable diversion limit to the baseline diversion limit. And we believe that if this process is followed, it allows the cap to be undermined in New South Wales and by extension in the basin. That's all.
Thank you. Move to you, Dr. Coloff. Do you have a statement?
Yes, I do. Look, DPIE has repeatedly claimed that floodplain harvesting take has increased above the legal limits set under the water sharing plans and the basin plan, and they were bringing floodplain harvesting within these limits. However, they've consistently failed to provide evidence of this. Accordingly, we undertook an assessment ourselves to develop a method to identify on-farm storages on the floodplain, calculate the capacity of on-farm storages, assess the change in total storage volume between 93 and 2020, estimate the volume of floodplain harvesting from annual take. And we estimated storage capacity of almost 1,400 gigalitres, a 2.5-fold increase since 1993, and an annual average take of 778 gigalitres, twice the volume modelled by DPIE. We conclude that the magnitude of floodplain harvesting diversions has had major negative impacts on downstream communities and ecosystems. We consider that floodplain harvesting is first and foremost a water justice issue, not just a water management issue. And we suggest some safeguards that need to be put in place under any licensing regime, including ensuring volumes of water harvested are legal and compliant with limits under the Basin Plan, as well as the setting and enforcement of downstream flow targets to be met before floodplain harvesting can commence, and improve monitoring and transparent reporting of the extent and magnitude of floodplain harvesting to ensure accurate, comprehensive, basin-wide water accounting, and to help communities adapt in a fair and just manner to a future under climate change. Thank you.
Thank you very much. And just to confirm, Ms. Slattery, do you have an opening statement as well? Yeah, okay, all right. Let us go to questions now from the opposition. I understand Mr. Adam Searle is kicking things off.
Thank you, Madam Chair. Adam Searle for the opposition. I wanted to ask some questions, Ms. Slattery, about your document licensing floodplain harvesting in northern New South Wales from about August 2021. Now, in that document, you outline there's a legislated process through the Murray-Darling Basin framework to establish the caps on water extraction, but you also make the case that the New South Wales government is promulgating what they call a cap scenario, which is a different and significantly higher cap, if I can use that term, for extraction, and they're using that scenario to justify their former regulation, which has been disallowed, their current approach to what the government says is going to be an efficient regulation of floodplain harvesting. Earlier today, we heard that the Murray-Darling Basin cap is just another cap scenario equivalent to any other cap. Can you just step us through why the legislated cap is important and why the New South Wales government cap scenario is not an appropriate method to set extraction limits? I don't think I can hear you, Ms. Slattery.
Yeah, Marianne, just if you could start again and unmute.
Sorry. The Murray-Darling Basin cap is set under the Murray-Darling Basin Agreement, which is a schedule to the Commonwealth Water Act. In New South Wales, the extraction limits must be the lower of cap or the limit in the plan. The DPIE have gone to when they've proposed new floodplain harvesting licences, have argued that floodplain harvesting has exceeded cap and they have brought it back within cap, but they're actually talking about a cap scenario model, which is a new model that has no official status rather than the official cap model. Now, the process for determining cap is set out in a schedule to the Murray-Darling Basin Agreement that prescribes what the baseline conditions are. It requires a list of diversion, a register of diversions that's agreed by Ministerial Council every year, and it requires the development of a model against the description of the cap. Now, that model needs to be approved by the Murray-Darling Basin Authority, and the Murray-Darling Basin Authority has agreed that it will only approve models once they have been independently accredited. That process has happened for nearly all of the valleys except for the Bowen-Darling Valley and I believe one other valley in Queensland. So they are the official cap models. You can't just go and label something else a cap scenario model or just give it a name like cap and expect it to have the same legal status as cap. It's a really important process that we've got a limit, and that limit has a process around it to ensure that we're sticking to that limit. Sorry, I can't hear you, Mr. Searle.
Sorry, so by relying on their cap scenario to inform state government policy, is it the case that the New South Wales government would be operating outside the Murray-Darling Basin framework?
Yes, that's my understanding of it. The cap scenario model has, it doesn't have an official status as a cap model. So yeah, they're not adhering to the cap.
And those cap scenarios are much higher
Sorry,
than...
order, Mr. Searle. I'm going to have to, so Marianne, every time you stop speaking, if you could mute and then unmute, that's frustrating, but that's what we're going to have to do because it's distorting heavily. Proceed, Mr. Searle.
So just to be clear, by the state government's cap scenario that they appear to be relying on, would permit much higher levels of water extraction and use than the Murray-Darling Basin set caps. That's correct?
Yes, that's correct. That's certainly the case for the Guida. So the cap scenario was much higher than the cap. And the DPI, the New South Wales Department, have said, oh, look, we've got this high level of floodplain harvesting, we're bringing it back to cap, when actually they're actually increasing cap by quite a substantial amount.
And what is the impact on the integrity of the Murray-Darling Basin framework if the state government was to proceed this way?
I don't think it's got any integrity, and it's clearly the government's intent is to mislead this process, to state that we're within cap, they're bringing licensing back within cap when it's clearly not. I think it's got absolutely no integrity, and yeah.
Thank you. Earlier today, we heard evidence from the food and fibre organisations, I think, in the Northern Basin, and at least some of their evidence said, look, focusing on storage capability is wrong and misdirected. It's about how the water is in fact used. And in your various submissions, you've set out how storage has increased by 2.5 times over the last 26 years, I think growing at nearly 10% a year. The state government itself has said, though, that water storage capability is vital to ascertaining floodplain harvesting entitlements. Is that your view?
Yes, the reason we undertook that exercise at Attachment A, which was to map the growth in floodplain harvesting storages, is because we've been saying to the department for several years, you have to demonstrate to stakeholders that floodplain harvesting is within cap, and we weren't getting any satisfactory answers. So we undertook to do that satellite imaging project ourselves to demonstrate what the growth in floodplain harvesting was. The growth in storages was, where storages are not a one-for-one for floodplain harvesting, but there's certainly an indication of the ability to take water. And the other reason that we were looking at storages is because at that time, DPIE was actually using the amount of storages as a way to determine the shares of how floodplain harvesting licences would be apportioned. So it was very close to the logic that the department was using. And there's 20 years worth of documentation about the relationship between floodplain harvesting and the capacity to take floodplain harvesting water and the size of storages.
So in your submission at page 22, you set out the different storage capabilities by valley, and you come out with a figure significantly greater than that ascertained by the department. How should we evaluate the differences in your evaluation of storage compared to the department's?
No, I think our storages were very closely aligned to the department. The thing that we did that the department didn't do was show the growth in storages from 1994. We've seen, so our numbers quite independently came out very close to what the government had published. I've seen in subsequent email exchanges between officers that were correspondence that became available under some standing order 52s that the department agreed with our 1994 figure as well. So the department agrees with us.
But storage capability is a very important pointer to floodplain harvesting. We shouldn't disregard storage capability as an important factor.
No, absolutely not. And also, if you go back to the criteria of CAP, which is the infrastructure, the rules, and the entitlements that existed in 1994. Yeah, that's the CAP. So that, we mapped out the infrastructure part of that equation.
Thanks, Madam Chair. Those are my questions. I think Ms Sharp will now lead for the opposition.
Thank you. Just to go back to the issue around cap versus cap scenario, how have other states dealt with this issue? If it has to actually be approved by the Murray-Darling Basin Authority, how are you able to tell us why New South Wales thinks it can do it differently?
I'm not aware of any other states cooking up a cap scenario model. It's a I'm not aware of other states doing it.
Right. So the explanation would be that so if this was to go through, then it would have to still be approved by the Murray-Darling Basin Authority, and your evidence is that it would be unlikely to be approved because it doesn't meet the requirements as set out in the plan.
If New South Wales wants to rely on a new cap and an amended cap, then they have to go submit a new model back to the Murray-Darling Basin Authority, who have to approve that model. And at the moment, my understanding, there was an agreement that they would only approve a model if it had been independently accredited. So I'm assuming that still stands. So they would have to go back through that process, yeah.
Thank you. In your submission, you talk particularly about the issues of the 500% carryover and the mathematical issues associated with that. We've obviously have evidence that over a 5-year period, given the likelihood of flood events, is likely that 5 years is a reasonable thing, and the carryover would provide greater certainty. Can you take us through your concerns with that?
It's really about it's not so much of an average annual amount over a time period. It's more about the starting with 500% in the bank. So if you start with 500% in the bank and then you rely on an average over, that's spread out over a certain number of years, you're always going to exceed. If there's water, you're always going to exceed that average take because you haven't started with an average. You've started with the kicker at the start. And a really good example of that is the Barwon-Darling water sharing plan. It's got very similar accounting rules, but started with 300% rather than 500%. This year, they've breached their sustainable diversion limit. MWA and NRA have gone to great pains to explain that no individual has exceeded their water licence, but the valley as a whole has exceeded, the water licences and accounting rules, but the valley as a whole has because of this issue around starting with something in the bank.
The argument from the department, and we've had some material on this, is that without doing this, that you'll each year you'll end up exceeding the target. Can you respond to that?
Well, it just doesn't make any sense. If you've got an average over 5 years and you allow 500% or 10 years and 1,000% or whatever it is, if you've got an average, then you can't exceed more than 1 year. So they must be making different assumptions in their models to demonstrate that.
Can I ask a question? It's because I'm not an accountant. In your submission, you talk about the need for it to be the need for it to be audited and for it to be done based on Australian auditing standards. My question about that is how is other water take undertaken, and is there a difference? Is it what you're pointing to a different standard of accounting, or is it the same as what happens for other water?
No, we're just saying that the total all water accounting needs to be improved. It's certainly a lot easier to measure something that's taken via a pump, for example, than it is for floodplain harvesting. It's a very difficult thing to measure, but there's no so the measurement is very poor. But in addition to that, you have no accountability, and I would extend that more so to the models as well, because the modelling is the modelling underpins everything, and the modelling is the compliance tool, and it's so open to manipulation that we just have no transparency over what is being done to those models.
So this isn't just a matter for floodplain harvesting; it's for other water take as well.
It is, but floodplain harvesting is the most problematic part of the water balance.
Thank you. I wanted to ask you for you to unpack the issue. I mean, you take issue with the Murray-Darling Basin Authority in relation to the water, obviously at Wilcannia, which being 40% less, which has been a huge concern, obviously, to the Barkindji and others. And, you know, the MDBA has said that that's about climate change. Can you just take us through why, you know, obviously you sort of state, well, research says that that's not the case. I just really want you to unpack that for us, please.
And I'll defer to Dr. Koloff in a second. I'll just quickly answer this because I know that he's been looking at this issue as well. There has been a decline in inflows into the Murray, and that example of a decline in inflows at Wilcannia. However, there's been no evidence that I'm aware of that can attribute all of that to climate change rather than a mixture of climate variability and also increased extractions. The Murray-Darling Basin Authority received a large data set for its 2020 evaluation from Bureau of Meteorology that was catchment inflows, and that showed in the last 20 years, which is the period that the Murray-Darling Basin Authority is blaming this decline, showing this decline. There was very little variation in the Northern Basin. It was slightly above average. There's other documents that MDBA, that we obtained through Freedom of Information, that MDBA have attributed the changes in the Barwon-Darling to more than climate variability, and that must be increased extractions. There's also the work that the Academy of Science did, and also Professor Rob Vertessi's team that looked at the fish kills that also, both of those two things talked about increased extractions. But I'll pass on to Dr. Koloff if I could.
Dr. Koloff.
Yeah, thank you. So in relation to that issue of the impacts of floodplain harvesting on the Barwon-Darling, yeah, as Marion Slattery says, both the two fish kills inquiries, that by the Australian Academy of Sciences and that by the so-called Vertessi report panel, both concluded that the root cause of fish kills was that there was not enough water in the Darling system to avoid catastrophic decline in condition through dry periods. And in both cases that they found, it was partly due to the fact that partly due to climate change, but also partly due to major diversions for irrigation in the Northern Basin. My colleague Quentin Grafton has recently produced a report in which he has examined the causes of hydrological drought and the consequences for resilience in the Northern Murray-Darling Basin, and has partitioned the effects of climate change from the effects of irrigation diversions, including floodplain harvesting. And his assessment is approximately a 50-50 between those two drivers of change.
Thank you. That's very helpful. I've only got a little bit of time. My final question is really just about accounting for cultural flow and deciding that. I know that you touch on this in your submission in relation to, obviously, Aboriginal communities up and down the various rivers have got firm views about this, but I'm just wondering if you could just let us know, you know, how under this proposed regime is cultural flow going to be able to be accounted for and or included?
Look, I might defer to my colleague, Mr. Johnson, to address that question, if I may.
I can't see how cultural flows or any water for Aboriginal communities can be accommodated under this proposal. I think it consolidates and institutionalises a further reduction in flows down the river and to those communities.
I think that's my time.
Exactly, spot on. Okay, we'll go to questions from the crossbench. I'll kick them off. I just wanted to We've been hearing about these potential changes to BDL and the CAP scenario and BDL scenario. What's wrong with updating these models with what is being called best available information? I think we're being told that that's always been allowed under the Murray-Darling Basin Agreement, that there is something called best available information that can be applied to things. Ms. Slattery, that's the response to what your complaints about the CAP scenario model. So what do you say to that?
Well, there's as I was explaining to Mr. Searle, there is actually a process to update CAP. It's a formal process to avoid exactly the situation that we're seeing, which is any new information is considered best available information, and therefore we can update the models and therefore the limits, the extraction limits, at a whim anytime we want, with zero accountability, zero transparency, and outside the parliamentary process. So we've gone through this massive amount of pain and disruption and aggravation between communities for the last more than a decade, and we're now at a situation where somebody in a back room can literally just change a number and that changes the limit. I mean, that's not a limit at all. The idea that it's best available information, there's no criteria for what that best available information is, there's no arbiter on who gets to decide what information is better or not. There's no accountability and no transparency. And I also think it's a misinterpretation of the Water Act, because the Water Act requires the water resource plans to be made with best available information. What is happening with the changing of the BDLs and the SDLs, it is actually changing, meaning that the sustainable diversion limit, the SDL, will no longer represent the environmentally sustainable level of take, which is a requirement under the Water Act. That means that a requirement for the water resource plan would effectively be overriding the requirement of the Water Act, which seems to contradict legal principles.
Okay, so you have said in your submission as well that when DPI say that floodplain harvesting volumes have been reduced to cap within the Guida Valley, you say that hasn't happened, it's not possible. Can you explain to the committee why you're saying that?
Well, the first thing is to go back and have a look at the official cap model for the Guida, which is has a very small component of floodplain harvesting in it, and the new proposal with the new cap scenario model isn't the same as the official cap model. So the department's just cooked up this new cap scenario model and said, oh, we've reduced it back to the cap scenario model, which is a completely unofficial model.
So does it look like because they can't keep the take within the cap, that they're changing the cap instead of reducing the take?
Yeah, exactly right. So floodplain harvesting has never been reported under cap. There's only a small amount in the original cap model. They've had a massive, they haven't regulated it or contained it. They've allowed it to grow. So of course you're not going to be able to bring it back into cap because it's too large and there was never room for it within cap in the first place. So the only way they can try to demonstrate that it's within cap is by changing the cap. What they're saying is the cap number, and trying to justify that they've actually brought it within cap when they haven't. They've just cooked up a new model.
You saw quite a few emails within that call for papers in the upper house. I know you've seen some of them that do seem to justify your concerns, that there are DPI officials that are talking about changing cap numbers, that they're talking about updating the modelling, talking about, well, kind of alarming actually statements about this. Did you want to just talk about some of the emails that you found?
Yeah, sure. And some of these were reported in the Sydney Morning Herald today. So there's discussions around exactly this point about you can't just cook up a new CAP scenario model. You have to stick within the official CAP. There's an official CAP process that, you know, this process is tied to the water sharing plans and the Murray-Darling Basin Agreement, and you can't just go and call something a new CAP scenario model. There was talk around, there was certainly a lot of discretion on behalf of the modelers. Do we, you know, change this number or that number? There's no sort of there was no sort of objectivity in relation to that or controls around that. It seemed to be how do we get the highest number for floodplain harvesting? You know, that was definitely a very large theme of the conversations in the correspondence from the SO52. There's a lot of talk about how poor the numbers are, how poor the modelling is, lots of references to magic numbers, just cooking something up, random number generators. You know, we'll have all sorts of problems if this ends up in court. We won't be able to defend it in court. There's no question that you know, the modelling process is just it's a bit of a joke, really. And certainly a lot of relying on individual decisions by individual modelers.
You also make a recommendation in your submission to establish a professional body of modelers. Is this I suppose, one of the reasons? Do you just want to expand on that recommendation?
Yeah, sure. So if you're an accountant or a lawyer, you've got a set of standards. You've got and some of those include ethical standards that you abide by. There's nothing like that for modelling. You know, anybody can be a modeler for a start. It's not as a strict discipline like accounting or law. So anyone can be a modeler. There's just no checks and balances over the process. Even with the best intention and good faith, it's still very subjective. There's not like an external, you know, quality control process to make sure that you know, what the models are doing and fit for purpose. And when you take away the process with CAP, and then there's nothing to replace that in the basin plan, there's no internal controls over that process at all. You know, we're seeing in this example that we've seen where we've just cooked up this new CAP scenario model, there's no professional repercussions on any of the people involved with that, the way there would be if there was if they were accountants or lawyers, for example, with their own professional code of ethics. So I think it's long overdue, particularly the extent to which we rely on the models to regulate water management in Australia and for our compliance. It's pretty extraordinary that is the only tool we're using, and we have got no controls over the application of that tool.
Thank you. Just quickly, my last final question, I'll go to you, Dr. Koloff. You say in the submission that you have put into the committee that the basin plan allows for a long-term average take of 46.3 gigalitres per year from floodplain harvesting in the northern catchments. So 46 gigalitres per year, that therefore is what you believe we should be seeing now. Is that right? You also say how much it's grown. So does it need to be taken back to 46 gigalitres? Is that your argument? Dr. Koloff?
Sorry, Ms. Fairman. No, it's not. Look, the estimates in the MDBA CAP compliance reports drastically underestimate rates of floodplain harvesting. They're little more than a guess. And they use the same figures year after year after year. And so really what was required as part of the development of the basin plan and the modelling was a proper assessment of the extent and magnitude of floodplain harvesting. What we really need to get a handle on is how much water is being taken out of the system, and how that is included in the sustainable diversion limit.
Okay, thank you. My time's expired. I'll go to Mr. Mark Banasiak.
Thank you, Chair. I just might start with you, Mr. Johnson. I just want to clarify, in your opening statement, you were listing some of your concerns, and I think I heard you say one of them was the linking of BDL and SDL. So I just want a bit of clarification on that, because my understanding is they are inexplicably linked, because the SDL basically equals BDL minus that 2750 that was recovered by the Commonwealth Government. So am I right in what I heard, that you said that you are concerned about some link between these two?
Yes, I am. I'm concerned that there's now a fixed volume difference between the SDL and the BDL. The BDL was an estimate or a measure of the amount of water that was being taken. The SDL is meant to reflect an ESLT or give force to an environmentally sustainable level of take. The two were two different methods to get the number. The BDL was really an estimate of use. That's called a measure or an estimate of use. The SDL was a reflection of the ESLT, which was the calculation of the environmental needs of rivers and wetlands. Now, whatever the shortcomings there might have been around that, there were two completely different processes. And the SDL was meant to be achieved by recovering water to a volume from the BDL. Now, they were never meant to be the volume between the reduction of the BDL was meant to be the amount required to achieve an SDL, which reflects the ESLT. They're not fixed. There's not a fixed relationship, and the department and the MBO have never been able to explain how it has become a fixed volume. They've also Brett Walker also said that it was not lawful. But simply the two methods are different. There is not a fixed relationship, and there shouldn't be a fixed relationship.
Okay, thank you. Ms. Slattery, in relation to questions, I think it was from Labor about growth in storage, can you provide a bit of comparison or context in terms of that growth in storage in the north compared to a growth in storage in the south from that same period? Do you have that data?
No, we haven't done that exercise. We did do a trial in the Murrumbidgee over quite a small area before we undertook the project, and there was a growth in on-farm storages in the Murrumbidgee for that area, and that was about around about Griffith. And there has been growth in on-farm storages in the Murrumbidgee Valley, certainly, particularly between Griffith and Hay, that have been funded under the Commonwealth's efficiency program, but we haven't done that exercise for the south.
Okay. Did that initial look indicate a similar level of growth or a projected similar level of growth?
I'd have to. We did it about 18 months ago. There was a large level of growth, but I couldn't tell you off the top of my head what it was, and it wasn't for the whole valley. But I can get that on notice if you want.
Yeah, that would be great. Thank you. I might just turn to a
sorry, Mr. Banasiak, I will just remind all witnesses and members to mute as every time you're not talking.
Thank you, Chair. I might just turn to a document that I've just tabled, and hopefully the committee secretariat has emailed it to you. It comes from the department, and it came via Twitter, talking about water allocation update. Now, one of the arguments we hear from the southern irrigators is that floodplain harvesting has a direct impact on the allocation that they receive. And this statement by the department talks about a payback system to the tune of 350,000 megallitres that was borrowed against an environmental water allowance. So I'm just curious as to how much of an impact on the southern irrigation's water allocation would such a payback, I guess, impact versus the claims of floodplain harvesting impacting water allocation. That seems a fairly significant amount of water that has been borrowed against an environmental water licence.
I haven't seen the document and I haven't got it in front of me. It hasn't come through from the Secretariat. So, but what I would say is that you're referring to the arrangements around the Barwon account. That's been in place since about the 90s, I think, so it's not a new thing. So you wouldn't expect that to, it would have an impact on allocations, but you wouldn't expect that to have a changed impact on allocations, certainly since the 90s. But I would argue that, you know, there has been a growth in extractions in the north, and that does have an impact on the Barwon-Darling-Barker, and that therefore has an impact on southern allocations. I don't see how anyone could argue otherwise.
Yeah, I just wanted some, I guess, a bit of context in terms of what such a payback would, you know, how that would compare to the impacts of floodplain harvesting. But perhaps because you haven't seen the document, I might just try and get the Secretary to email it to you, and perhaps on notice you might be able to come back with some further comments. I'm just conscious I might be running out of time shortly, so if that's okay, Ms. Slattery. Yeah, thank you. My other question was to you, Mr. Koloff. You in relation to Ms. Fairman's questions, you were saying that they've been using the same figures every year, but is it not the case that one of the reasons they've been using those same figures is that it hasn't been measured, it hasn't been metered, and to get updated figures, you actually have to do the measuring and the metering?
Well, my response to that was that using basic principles of water accounting and using publicly available data, we were able to estimate the mean annual floodplain harvesting take for 5 river valleys in the Northern Basin, and they vary from year to year. Now, if we can do that, then surely Murray-Darling Basin Authority and DPIE, with all the resources they have available, can do that too.
Okay, and I might just quickly jump back to you, Ms. Slattery. This cap versus cap scenario, is this something new that's come out from the department since the disallowance of the regs? Because this is, I guess, the submissions that have come through during this inquiry is the first we've really heard, or I've personally really heard, of this cap scenario. Is this a recent invention from the disallowance, or was this happening before?
The first time I saw reference to a cap scenario was when the Guida Valley, the reporting around the proposed licensing for the Guida Valley was published. Now, I think that was towards the end of last year, so it would have been after the first regulation disallowance, but before the second ones. So, and they changed names for, you know, they changed their names on their different scenario runs all the time. But that's the first time I saw the cap scenario.
Okay. Does the cap, as it's scheduled in, or as it's described in Schedule E, combined with the latest disallowed regs, would have that properly transferred the 1912 licenses over to 2000?
Sorry, you'll have to ask that question again.
So as the cap is described in Schedule E, of the Commonwealth Water Act, not the cap scenario, but as it's described in Schedule E, with the most recent disallowed regs, in your view, would that have provided the mechanism to transfer the 1912 licenses over to 2000? You're just on mute, Ms. Slattery.
That's a really complicated legal question that I'm not going to attempt to answer. But I would say that the cap is very clear around that you must have the infrastructure, the entitlements and the rules at 1994. And if the floodplain harvesting, well, there were no floodplain harvesting entitlements in 1994. I think it's arguable about the rules that were in place for floodplain harvesting as opposed to the absence of it being illegal. So I think there's a good question there for Brett Walker and the other lawyers that are appearing before you. Would, you know, just because floodplain harvesting was not illegal prior to, was not illegal doesn't mean that it was within the rules and the entitlements. And similarly for the baseline diversion limit, the baseline diversion limit says what is law under state management law at 2009. And if floodplain harvesting wasn't within state management law at 2009, then it can't be part of the BDL. So they're questions for a lawyer.
Thank you, Ms. Slattery. That's my time expired, so I'll hand to the government.
Yeah, we'll go to the government now. Ben, is that you waving? Yeah, Mr. Franklin.
Thank you very much, Chair, and thank you all for being here today. I'll start with you, Ms. Slattery, if I may. We obviously spoke, I think, last time at the dams inquiry, so we've talked a little bit, but I just wanted to get a couple of things clarified to start with. You're a consultant with a range of organisations. You work with them on providing advice and information and recommendations about how they should proceed in their different strategies. Is that right?
We do. Well, I would ask how this is relevant to the terms of reference for this inquiry.
It's relevant. Just, I mean, this isn't actually a gotcha question. It's I want to talk about something that was in the newspaper and that is relevant to the Southern Riverina irrigators. So I was just, I guess, making some context. So is that correct?
We provide information to a range of clients across the basin.
And you're currently working with Southern Riverina irrigators?
Southern Riverina irrigators are a client of ours, yes.
Cool. How long have you been working with them, just out of interest?
Again, I would ask how this is relevant to the terms of reference for this inquiry.
I think point of order, I think is being taken by Ms. Penny Sharp.
Thank you. It's a similar one to the point of order that I made earlier today. The questions should be about the terms of reference of this inquiry. I think that Ms. Slattery's answered the question and that Mr. Franklin should move on and actually ask questions about the submission and within the terms and reference of this particular inquiry.
I just didn't think to the point of order that the witness would be embarrassed about how long she's worked with a client. I don't understand why that's something that's...
There's no need to also be rude to the witnesses before us.
I'm not being rude to the witness at all.
And to the point of order, like we haven't even gotten to the substance of the question because we're trying to get some context there, and because it doesn't suit some on their agenda, you call a point of order. So I think it should be Ben is well and...
Well, just to the point of order, Madam Chair, just to the point of order,
yes, Mr.
it really will smooth proceedings if members directed their questions to witnesses about matters relating to the terms of the inquiry and their evidence before us today. That's a very wide ambit, and with the greatest of respect to my friend, Mr. Franklin, I think he has strayed beyond that.
I'm quite fine about continuing on without you telling me how long you've worked with Southern Riverina irrigators.
Mr. Franklin, can I just reiterate for everybody to please...
You're now wasting my time.
Excuse me, to please remember that witnesses, in terms of procedural fairness resolution, to treat them with respect and courtesy at all times. If you could continue, thank you.
Sure. Also, though, can I say, when the witness says statements like, clearly the government's intention is to mislead, as a representative of that government, I don't think it's unreasonable to prosecute the case against that witness. Anyway, we'll move on. Can I ask Ms. Slattery, are you aware of the legal advice from Brett Walker SC to this inquiry that's now been published today?
Yes, I'm aware that it's been published, and I had a quick glance at an article in the Weekly Times that was produced very, very quickly after that legal advice was published. Yeah.
I'm not sure if it's the same one. Oh, have you actually had a chance to look at that legal advice yet?
No, I haven't read it, but I've heard. I think I've got the gist of it from different conversations, but I haven't read it myself.
Righto. I'm not sure if the Weekly Times article is the same one that I'm referring to now. There was a letter in the Deniliquin Pastoral Times, which was on the 14th of September from the Executive Officer of Southern Riverina Irrigators, which refers to, it says as follows, they talk about raising some money for a voluntary levy, blah, blah, blah. And they said, that's allowed us to engage the services of Brett Walker SC, who's considered one of Australia's formative minds on the matter. His report in the up-and-coming New South Wales Upper House inquiry confirms SRI's position, FPH has never been legal. So my question is that a different report to the one that is currently being submitted to this inquiry, or are they the same thing?
You'd have to ask. You'd have to ask the author of that. I'm not aware of that letter. You'll have to ask the author of that letter what they were referring to. Our submission that we've put into this committee raises very different legal questions to the questions that I understand were asked of Brett Walker by the committee. So the committee asked Brett, according to the Peter Hunt article, the committee asked Brett Walker some very specific questions in relation to offences under the Water Management Act. The issues that we've raised in our submission go to an interaction between state and federal law, the cap under the Murray-Darling Basin Agreement and the Water Act, the relationship between the SDL and the Sustainable Diversion Limit and the Baseline Diversion Limit in the Water Act and the Basin Plan, the relationship between the Sustainable Diversion Limit and the environmentally sustainable level of take in the Water Act, the ability to change the Basin Plan through the BDL and the SDL without going through the parliamentary process at the federal level, not removing volumetric limits out of the state legislation with the new water sharing plans. So we've raised very different questions that need a legal interpretation to the ones that the committee asked Brett Walker.
I understand what you're saying. I guess I'm just confused, and I was wondering if you could clarify. So it says in this letter from the lady who represents an organisation that you said was your client, that FPH has never been legal. And yet in the advice that we received today from the question, is there any circumstance under which the take of water through floodplain harvesting could be considered a legal activity? His response was, the answer is straightforward. The circumstances that have obtained for generations are, it turns out, circumstances under which the take of water through floodplain harvesting should be considered, not merely could be considered, a legal activity. That is, of course, that is in fact legal. And the answer to a very broad question is that it's legal. Do you disagree with that premise? And
I haven't read the letter. SRI is a client, but that means we give them advice when asked. It doesn't mean that we dictate their operations. It doesn't mean that we write their letters for them. Haven't even read the letter. So
that's
I can't comment.
I'm just trying to clarify. So you think that they're probably wrong when they say that FPH is...
Please don't put words in my mouth.
Right.
I'm here to talk about our submission, where we have raised a lot of questions around the making of these floodplain harvesting licenses and around the volumetric limits and MWA and DPIE or New South Wales seeming to remove volumetric limits out of any legislation, state or federally, in relation to the basin plan. And all of the interaction with that, I can talk to that. I can't talk to a letter that somebody else has written that I haven't read.
Understood. When Brett Walker says in answer to the question, is the take of water through floodplain harvesting a legal activity under the Water Act 1912, and he says it follows that the proper answer to that question is yes, do you agree with that?
I'm not a lawyer. We think there are a whole lot of issues in relation to the licensing of floodplain harvesting and potentially the legality, and there's several areas that looks to me as a non-lawyer that looks as though there's very questionable legal practices that are very separate to the questions that this committee put to Brett Walker.
Even though Brett Walker, who is acting, sorry, with respect, I'm just pursuing a line of questioning.
Well, it's a line of questioning that's completely out of order.
This is directly relevant to the terms of reference, Madam Chair.
No, it's not. This is we have got Ms. Slattery has said that she hasn't read the advice. You're now reading out pieces of the advice which have been published publicly. You could ask Ms. Slattery to take it on notice and actually come back to you with answers, but it is extremely unfair to ask a witness to try and deal with a piece of paper that she hasn't actually read and then make assertions about clients that she may or may not be working with and what letters that they may or may not have written that, again, she hasn't said. It's completely out of order.
Well, yes, the witness has said that she has as a client the Southern Riverina Irrigators, who have publicly said they've engaged Brett Walker SC. That's on the public record, and I'm trying to work out how that works. When he said to us it's an illegal activity, and they contend that it is an illegal activity, how she can reconcile that? Because she's
Ms. Slattery has nothing to do with it.
Madam Chair, point of order, Madam Chair.
Yes.
This is getting very close to someone's legal privilege. If Mr. Walker has been commissioned by clients to provide them with legal advice about matters, that is a matter for Mr. Walker and those clients, not a matter for Ms. Slattery, with respect. And Ms. Slattery can't be called upon to interrogate or divulge anything she knows or doesn't know about that other advice. And this committee and its members have no business inquiring into those matters. We can take this matter up with Mr. Walker or with us and irrigators on another occasion, but not Ms. Slattery.
Thank you, Mr. Searle. And yes, we do have Mr. Walker on Friday morning.
Sure.
Mr. Franklin, if you can
Thank
continue.
you very much. I'll move on to an entirely different line of questioning. Ms. Slattery, could you tell me, do you agree with the New South Wales government's push to change the River Murray Agreement to ensure they regain control with a deliverable 480 gigalitres of water?
Sorry, you'll have to restate that question.
Sorry, do you agree with what the New South Wales government's approach is to push to change the River Murray Agreement to ensure that they regain control with a deliverable 480 gigalitres of water?
I'm sorry, I don't know what you're talking about. I don't know what agreement is being proposed. Are you talking about Menindee Lakes?
Yes.
Sorry, I wasn't aware that there was a proposal to change the agreement. I know that there's been talks about Menindee Lakes going on for 20 odd years. I know that that will require a change to the Murray-Darling Basin Agreement.
So would you support that?
I don't know anything about the proposal.
Oh, well, I'm just asking the question. Would you support the Menindee Lakes having a deliverable 480 gigs so that they're not drained, basically? That's my question.
It's a really, I'm sorry, with respect, it's a very strange question. The Murray-Darling Basin...
If I could just interrupt Ms. Slattery. Is Penny Sharp again on a point of order?
Point of order being that these questions have nothing to do with the floodplain harvesting inquiry, which is what this session is supposed to be about. And I'd ask Mr. Franklin, I'd ask you to ask Mr. Franklin to actually ask questions that are within the terms and reference of the inquiry.
Yes, Mr. Franklin, with the line of questioning that you did have, if you could please bring it back to the terms of reference. Thank you.
With respect, so many submissions and witnesses have talked about the Menindee Lakes. If that's suddenly off the table, I think that's a pretty extraordinary comment. Why don't we move to something else? Ms. Slattery, can you tell us, does floodplain harvesting occur in other states? And if so, how is it licensed and enforced?
It occurs in Queensland. I'm not aware of it occurring in Victoria or South Australia.
And how's licensed and enforced in Queensland? If you prefer to take that on notice, I understand that might be quite complex.
Yeah, I haven't looked into Queensland in a great lot of detail. I've heard that it's probably pretty cowboy territory there as well.
Right. Okay. I might just go to Dr. Koloff, if that's all right. Just a final couple of questions. I Googled an article that you were quoted in, Dr. Koloff, I think in the Sydney Morning Herald on the 9th of May, entitled "Like the Anti-Climate Change Brigade, Water Scientists Under Attack." And you talked about the basin plan being subject to a process of administrative capture, whereby some scientists are incentivised to constrain the scientific questions asked, limit debates and promote policy approaches favoured by decision makers. I guess I was wondering if you could speak a little more to that, because I find that troubling when people, potentially are paying so-called experts, and we should potentially be considering their motives. Could you speak about that issue for us?
Thank you, Mr. Franklin, for your question. I'm not sure how your question is relevant to this inquiry. It's not about floodplain harvesting. I'm here as a scientific expert to answer questions about floodplain harvesting. So I'd be grateful if you directed your questions to that issue and to the submission that I put in conjointly with Slattery and Johnson, entitled "An Unsustainable Level of Take on Farm Storages and Floodplain Water Harvesting in the Northern Murray-Darling Basin." Thank you.
Okay, I was trying to discuss the broader context through which this whole debate is happening, and was just hoping for some clarity on your views. But that's okay. I mean, I guess we just heard evidence where we were told that the department was cooking things up, and there were some experts who were described as cowboys. And I guess I was looking into that issue further, and to discuss broadly what makes an expert and what makes a good debate and an informed debate in this. But if you'd prefer not to discuss it, that's understandable. I'm okay to move on. I'm happy for any witnesses to answer this question. I was just picking up on a line of questioning from Ms. Sharp, which was basically, are there instances where other states have adjusted their baseline diversion limit or their sustainable diversion limit? And if there aren't, how would that happen, and what are your views on that?
I can answer that. Yeah, the baseline diversion limit and the sustainable diversion limit has been increased in each of the other states. I understand that was done through the Water Resource Plan process. Ms. Sharp's question was specifically in relation to presenting a CAP scenario model as CAP. I'm not aware of that happening anywhere else, but the basin plan limits, the baseline diversion limit, the sustainable diversion limit have been increased in the other states. And we would argue that should have been done through the parliamentary process set out in the Water Act and the Basin Plan, not in, behind the scenes deal with MWA in the relevant state.
Righto. And just finally, I know that my time's almost done. I know I asked you, Ms. Slattery, about floodplain harvesting occurring in other states, and you discussed obviously the issue of Queensland. Would either of the other two witnesses like to talk about basically that example and how that, the lessons there that could be learned by New South Wales that are worthy of discussing, how it's licensed and enforced and so forth? Again, you can take it on notice if you wish, or if you don't have anything to add, that's fine.
I don't have anything to add. Queensland has a form of licensing system, but I'm not familiar with it. Mr. Johnson may have something to say. I don't know.
No, I don't have anything to add.
Okay, wonderful. Thank you.
My questions. Thank you, Madam Chair.
That's the end of this session. So thank you very much to the witnesses who appeared today, and for all of your good extensive work. We will now have a quick break. In fact, that is the end of today's hearing. So thank you all very much. Thank you. And I believe our live feed will finish soon. So thanks for